participating in the hearings that you're undertaking. For the introduction, Bay of Many Coves is a resort and a lodge in the Marlborough Sounds. It's a relative new entrance in the Sounds, but we have built up a very successful international track record. We're one of only 4 resorts in the Sounds, and the Sounds, as you're probably aware, account for something like 20% of New Zealand's coastline. So it's a fairly significant block of water, and certainly a substantial destination for international tourists coming to New Zealand. In the period that we've been opened, we've had about 30,000 guests through the lodge, at least 80% of them being international. So we're a very significant provider and a contributor to the Queen Charlotte Track and the other facilities in the Marlborough province. Our biggest issue is that while the resort is mainly built on private land, the narrow foreshore strip, which is preferably referred to as the Queen's Chain, represents a significant portion of the footage leading onto the foreshore. Some years ago, there was a very clear principle that the foreshore would be opened up to the public, a principle which we totally agreed with and confirmed with, along with many others in the Sounds. And we've enjoyed the cooperative participation with the Department of Conservation, who administered that land and over the past period with the introduction of a Sounds foreshore licence. That licence ensured a continuing and renewable occupancy and access over that strip of land, enabling the extensive development of our resort and indeed the private populations within the Sound. The reserve is a very significant part of our operations. All of our passengers or our guests arrive by air or by water. There's no road into the resort. So it's a very important part of the frontage of our resort. We've recently expanded the land holding and put in a new wharf. We've upgraded our helipad for the accessing of the place, but nothing takes the place of the importance of the foreshore reserve. Without the tenure on that foreshore service area guaranteed, then very clearly it makes our plans for the further development of the place somewhat questionable, and we've totally supported the emergence of what is proclaimed within the bill that's been considered at this position of time. But anyway, I know that time is very limited, and you probably want to more focus upon the aspects of the bill. And I'll pass it across to James just to talk about the history and the position that we find ourselves in.
Yeah. Thank you. So just to clarify, the terms of occupancy on the reserve have historically been these perpetually renewable licenses that were issued under the Reserves Act. There were legislative changes made in 1996 of the Conservation Act, which were recently finally interpreted to suggest that DOC, who are the administering authority, only had the ability to issue fixed-term concessions. And so DOC's position has been to replace the perpetually renewable licenses regime with a fixed-term concessions regime. And that, we think, cuts right across sort of personal, sort of private property rights. And that's one of the principles of the regulatory, the current bill under consideration. We think it's a key aspect of development of the tourism industry and partnership with the private sector, that sufficient security of tenure and, in our case, perpetual occupancy rights is absolutely required to provide the foundation for long-term investment to grow that industry. And we think that had the regulatory principles bill been in place when those amendments were effected, the impact on private property rights would have been highlighted, would have been considered, and we understand that Parliament can do what it likes, but at least that would have been at the forefront of people's minds. And if required, compensation would have been considered. But I think that's enough, perhaps, from us. If we'd like to hand it over to the panel for any questions.
Thank you. I'll just kick off. So essentially, have you got a commercial practice, or is it just private land that's providing this uncertainty or potential uncertainty that you've got at the moment?
Now, most of the resort or the lodge is built on our private land. It's just the foreshore area, which gives us the certainty of access and the accepted terms of occupancy. Some of the facilities, such as the crossing to the wharf, are essential elements for the running of the lodge. But it's the biggest area of issue, and the sole focus is upon the Sounds Foreshore Reserve as it's currently defined.
So have you got a current period of guarantee or certainty, or is it currently all up in the air, or what's the time frame?
Yes, thanks. When the resort was built just about 2 decades ago, it's certainly following the turn of this current short-term century, there was a Sounds Foreshore Reserve licence. That licence gave the comfort to us and to all other parties for 10 years in terms of access and occupancy, and included within it was a automatic, as long as there had been continued abeyance on our part, I suppose, there was the certainty of the renewal of the licence. That gave us the continuing footprint and the confidence to undertake the expansion that we have in the period since we've been involved in it.
Yeah, thank you. A question from Dr. Deborah Russell.
It was that issue I want to focus on. So you've got a licence, you had an initial 10-year licence, and then it could be renewed. Was that going to have to be renewed every 10 years, or what was I didn't quite quite have the understanding there.
Yeah, the 10, they were 10-year perpetually renewable licenses. So license for 10 years, but included in the license is a term that it may be at the holder's option renewed for a further period of 10 years, including that right of renewal.
Right. So, but that was going to roll every 10 years, was it?
Correct. Yes.
So in a sense, it wasn't, you could renew it, but in a sense, it was a perpetual license, provided you renewed it every 10 years, they couldn't interrupt it.
Yeah, save for public interest, but which we interpret as being a very high bar.
Public interest. Okay, yeah. Okay.
I'm sorry.
Sorry.
I was just going to say, I think it's always been commonly understood to have been a perpetual license.
Right, and that's under threat now.
It's in a state of confusion as a result of the interpretation of the amendments to the Conservation Act in 1996.
Right, so a fix is actually the amendment, making sure that gets sorted properly. You don't necessarily need this bill to fix it.
Yes, that's right. Yes.
Yeah, okay. So there are other routes to fixing the particular problem.
This particular problem, yeah. I guess we wanted to highlight it as, this problem may have been avoided had this regulatory standards bill been in place at the time.
Who knows?
Or at least it would have been highlighted.
It could have been highlighted through other. We've got other mechanisms for it though as well, like the Legislative Review Committee and the the Regulations Committee and things like that. This is not the only route to fixing it. Yep.
But no, that's a clear point. Thank you, Deborah. Thank you for bringing that up for our attention. All right, that brings us to the end of time. Gentlemen, thank you for your submission today.
Thank you for your time.
Enjoy your day. Cheers.
You too. We're now going to welcome David Harvey in the capacity of a personal submission. Welcome, David. We've got 5 minutes with you, but of course you can save some time for questions at the end.
Yes, thank you, Mr. Chairman. My background and qualifications are set out in my written submission. What I'd like to do is just address 4 major themes that arise from that submission. First, every piece of legislation that is enacted involves an erosion or some form of interference with individual or corporate liberty. That's the first point. The second theme is that the Regulatory Standards Bill, in fact, recognises this. and it sets out various principles against which legislation should be measured. Now, this involves a process of legislative balancing, with which I am sure most politicians are quite familiar with. But it is not, I would emphasize, an example of libertarian ideology. The third point is that the bill is not constitutional, and there have been some arguments put forward both in the media and by way of publication, that it is. It is not. It is, in fact, procedural. It can be amended. It can be repealed by subsequent governments, and it can, like the New Zealand Bill of Rights Act 1990, be ignored in the legislative process. The only thing is that if it is going to be ignored, those who are responsible for ignoring it are going to have to stand up and say why. Finally, and the final theme is that the bill should reference the Treaty of Waitangi, simply because it involves elements of governance and it involves elements of equal application of the law, Articles 1 and 3 of the treaty. And for those reasons, there should be some recognition of the treaty, and I'm not exactly sure how that should be done, within the scope of the bill. And those are the four themes that I wanted to point out, and I'm very happy to answer any questions.
Thank you. Very succinctly provided. Dr. Deborah Russell.
Thank you for that submission. I just want to understand what notion of liberty you're working with, because you've said what I think is quite a contentious claim that every piece of law infringes on liberty. Was something to that effect. Could you just tell me what notion of liberty you're working with, please?
You're familiar with Jean-Jacques Rousseau?
I have a PhD in political theory, so
Right.
I'm familiar with Hobbes.
So you know the opening sentence.
I'm not a Rousseau, and there's no need to patronise me. I'm asking you what notion of liberty you're working with.
Okay, man is born free, but everywhere he is in chains, and the chains, in fact, are legislation. Everywhere, any time that you enact a piece of legislation, you infringe upon a person's liberty, freedom of action, or ability to choose.
So you don't buy into the notion then that in actual fact the laws can create our liberties, which is the Harringtonian notion, or the notion that comes to us through the civic republican tradition, as opposed to the liberal or libertarian tradition?
No, I'm more a person from the Enlightenment, Dr. Russell.
Well, so am I, and I'm afraid that you just stating that as a notion of liberty, it's actually a deeply contested view of liberty. So that does rather undermine the view that every piece... It may be deeply
contested, but it might be one to which I adhere.
Right, okay, well, I adhere to a different one. Thank you.
Okay. Yeah, well, it figures, I understand that.
Yeah, nothing like a good academic jousting on a Tuesday morning. Have we got any more questions?
Mr. Chair.
Cameron Luxton.
Thank you, Chair. Just questioning, David, your assertion of the Articles 1 and 3 of the treaty needing to be included. Do you think that those two articles, as opposed to the third and the preamble, do you think they are accounted for in the principles that do you not think they are accounted for in the principles that this bill proposes?
Okay, in a very vague sense they are, but I think that there needs to be more specificity. One of the big criticisms of the bill is that it doesn't have a reference to or include aspects of the treaty. Now, I'm not one who suggests that the treaty has a place in every piece of legislation, but because there are elements of governance and because there are elements of equal application, I think that has got to be made clear and should be referenced within the bill.
So your suggestion is of governance and equal application. How would the equal application principle, if you were to, I know you said you didn't have one in mind, but how would you add a sentence or clause to reference equal application?
I'm not a statutory draftsman, Mr. Luxton, and I didn't come here prepared to do any statutory drafting. I'm sure that were I given time, I would be able to do that, but I don't have that at the moment, since I note that the 5 minutes is beginning to run out.
Okay.
I'm still recovering from my academic dispute with Dr. Russell, so...
You are right. We are out of time, David, but appreciate your submission, and it was good to get some engagement. Some submitters tend to talk too much, so it's good to have some back and forth. Appreciate your making both your written and oral submission this morning.
Thank you, Mr. Chair. The detail is in the document.
Yeah, thank you.
Thank you.
We're now going to welcome Rebecca from Parents of Vision Impaired New Zealand. Rebecca Graham, good morning and nice to see you again.
Oh, good morning. It's nice to be here. Now, is it showing on your screens? Because I seem to be a bit blank on mine.
Yes, we can see your screen share.
Ta-da! And look, there I am as well.
Perfect. Morena.
Morena. So I'm here on behalf of Parents of Vision Impaired, where I am the National Director, and we're a charity that engages in a lot of peer support and advocacy on behalf of our families. Our families are parents of a blind, deafblind, low vision or vision impaired child or young person, or sometimes a bit older. Our families come from across the country in all walks of life. And as we say, disability doesn't discriminate. So some very hard-working mums and dads. You would have seen in our written submission on the Regulatory Standards Bill that we are really concerned about this bill because it doesn't consider the international conventions that New Zealand is a signatory to, with particular attention being given to the United Nations Convention on the Rights of Persons with Disabilities. We're also concerned because the Regulatory Standards Bill doesn't really take a human rights approach, and that it doesn't really allow for what our families in our community would need and what supports them. Our families know that we are very much stronger together. We are very reliant on each other, both on our own families, but also in the communities and the connections that we have. And it's those communities and connections that our families draw support from and encouragement from and help us to keep going when sometimes it gets really hard. We are concerned that the Regulatory Standards Bill would prevent or slow down good lawmaking. And by good lawmaking, I mean legislation that would have positive outcomes for our families. It also creates another layer of red tape. It adds additional bureaucracy and makes it harder for our elected representatives to create and pass legislation that results in the type of positive material difference to our parents' lives. And that sounds very abstract. So what I've done is I've got a couple of examples of previous legislation to help try and make it a lot more concrete. So, for example, we have the Copyright, New Technologies and Other Matters Amendment Act from 2008, particularly thinking about Part 6, which is provisions for the print disabled. So this amendment back in 2008 was introduced because we needed particular copyright exceptions which would allow the creation and distribution of copies of material, written material in accessible formats. And by accessible formats, I'm talking about things like Braille, about large print, about audio. And what this bill did is it meant that organisations like Blind Low Vision New Zealand, previously known as the Blind Foundation, and BLENZ, the Blind Low Vision Education Network New Zealand, could then create, Braille and large print copies of books without requiring the explicit permission from the copyright holder. And so this bill understandably removed some very long-standing legal barriers that kept blind and low vision and deafblind people from being able to access books, being able to access learning materials, and anything that had a copyright on it. It also meant that New Zealand was now aligned with the international disability rights norms. And from this bill, New Zealand then went on to reinforce the Marrakesh Treaty, which again is about international disability rights. If the Regulatory Standards Bill had been in play at the time, it would have made it incredibly difficult for this legislation to pass. And if the Regulatory Standards Bill is passed, because of what it includes about going back over past legislation, it places this legislation at risk. And reasons behind that is that copyright is considered a form of intellectual property, and the Regulatory Standards Bill has property rights as more important than things like human rights and access to books and materials for blind persons. Also, the Regulatory Standards Bill talks about having quantifiable cost benefit, but the benefits of accessibility and inclusion are a lot more difficult to measure in dollars. Not impossible, but it's quite hard. And a lot of the economic measures don't really account for long-term benefits of accessibility. So, in summary, for this bill, the Regulatory Standards Bill would end up prioritising the rights of copyright holders rather than the rights of our blind population, our blind citizens, our children, to be able to access information. Another example that is directly relevant to our families is very long-winded New Zealand Public Health and Disability Support Services Payment for Care of Children Amendment Act in 2020. And that act primarily repealed Part 4A of the New Zealand Public Health and Disability Act 2000. This was a really important piece of legislation for our families because it removed the restrictions that had been in place, which meant that family members could not be paid for providing disability support services to their children or to a family member. And this repeal really removes some of the discriminatory elements that had been in play from the previous legislation. Also, that bill meant that disabled people could choose who provided their care, and if they wanted a family member to provide care, they could pay that family member at the same rates as what they would pay a non-family caregiver, which is a really important piece of legislation, particularly for mums, who are often the ones who give up paid employment to provide care for a child. It also worked to alleviate some of the poverty that was occurring in families, and it acknowledged caregiving as a legitimate skilled piece of work over and above or different to parenting. The challenges this piece of bill would face under the Regulatory Standards Bill include challenges around property rights and economic neutrality, because you could make the argument that the government is unfairly advantaging one group over another. Again, the cost-benefit analysis is tricky, because if you're only including the quantifiable economic benefits, you're ignoring what it leaves out. This bill leaves out the human rights, the benefits from human rights, lived experience, and long-term social good. And there's a potential argument around government not interfering in private family matters, which would make it harder to justify the public funding of this type of arrangement. So there was a potential there that under the Regulatory Standards Bill, this change in legislation, which has been really valuable for families, could be dismissed as too expensive, too complex, or even ideologically incompatible with the bill, with the lens that the bill demands. I'm going to stop there because it means we have time for questions.
That's right. Well done. We've got a question from Dr. Deborah Russell.
Hey, Rebecca, good to see you. And thank you for your continued work in this area. Look, there's a couple of things I found interesting. One is you really have brought out that the cost-benefit analysis may be too short-term. What do you think might be an appropriate sort of length of time over which to try to measure costs and benefits? Sorry, I know that's almost an impossible question to answer, but have you got a sense there?
Yes, only because I've read a report that Whaikaha recently released around economic costs and benefits, in which they admitted it was very hard to measure these things. One of the things they looked at was education in that report and trying to measure the economic impact. And what they came up with was that because we failed to ensure that our children, disabled children, have an inclusive education, this then creates a whole raft of long-term disadvantage over their life course. And I can't remember the figures off the top of my head, but I know the report came from Whaikaha, so they can probably provide some more detail there.
Okay, and just another point in that regard, it's really well brought out in your written submission around intersectionality and the impact on, particularly on Māori and Pacifica children, of some of the issues you've raised. Do you want to speak to that a little bit for the benefit of the committee?
Sure. It is really challenging, particularly for Māori and Pacifica whānau who face additional barriers over and on top of other families. And that pertains particularly in health to the way in which racism ends up embedded in all sorts of strange ways. And it's hard again to quantify that. And one of the reasons it's hard is that a lot of Pākehā don't experience those barriers. And so it's hard for us to talk to them. And the reason I'm so aware of them is that over our lifetime, seeing the way the atmosphere shifts, the way people change their attitude, the way people change their interactions to my family who are Māori, when I'm in the room and when I'm not in the room. And there are times when there has been a really noticeable shift and change. And legislating to ensure that equity and health occurs and having decision-making powers for Māori organisations is a really powerful way of shifting that at a structural and systemic level. And what the regulatory standards bill is, it undermines that and underpicks that, and it doesn't recognise that actually some of these inequities exist and that we need to be able to provide legislation and support to help shift at a systems level, at a social level, so that all of our families get equitable access to the healthcare and supports that they need.
Thank you, Rebecca. We have met time, but appreciate your submission, and certainly raises some unique points we haven't yet seen in the process. So thank you for that.
Thank you for having me. Ka kite.
Ka kite. We're now going to welcome Garry Moore in the capacity of a personal submission. Are you there, Garry?
I am.
Yes, you are, sir. We've got 5 minutes with you.
Now unmuted.
You're unmuted. We just can't see you.
Sorry.
There you go.
How's that?
In your hands.
Thank you very much. Today I'm speaking as a former local body mayor with a lifetime interest in 50-year interest in politics, and I'm not a member of any political party. So I'm wanting, you've got my submission, but I want to speak about the process. And I'm speaking particularly to the National and the New Zealand First Committee members. I've been involved in very many negotiations over the years. And what happened with the coalition agreement was, in my opinion, not everything was well thought through. To remind the National and New Zealand First members, a number of times this proposed legislation has been rejected by your parties already. What's the difference? Did your voters vote for National or New Zealand First, or for the party which won 8% of the votes that's promoting this bill? The fundamental essence of this bill is it effectively reduces decisions down to individual benefits and the impact of cost-benefit ratios. It reminds me of the saying by Oscar Wilde of the fact that we know the price of everything and the value of nothing. And in local government, that's the thing we had to balance at all times. It places the power onto one minister who chooses their own advisors. That to me is dangerous. I would never, ever have operated that way as a mayor. And the government advisors that have reported to your committee have actually come up with the similar criticisms. And I found it distressing to observe the minister promoting this bill lambasting critics who are making submissions. Our council here in Christchurch had a report to the council. They had a debate, they had a vote, and there are no votes recorded against their submissions. And the minister called them Putins. Sir Geoffrey Palmer, a distinguished jurist, and others were told they don't understand lawmaking. I think there are very few people in New Zealand who understand lawmaking better than Sir Geoffrey. So let me go back to the coalition agreement. Again, I speak to National and New Zealand First ministers, members of the Select Committee. Are you being whipped into line to completely turn the Select Committee process into what is essentially a theatrical farce? Why is an important constitutional bill being rushed into only having 30 hours of submissions? Who made that decision? It is possible to challenge the coalition agreement. Winston Peters did that in a very clever twist of the scrum over the inter-island ferry. He announced that there would be an announcement on the 15th of December. And on the 15th of December, the announcement was he was going to become Minister of Railways. He managed to twist the scrum so he didn't break the coalition agreement, but he kept the essence of what was important. And for that, as South Islanders, we're grateful. So in conclusion, I'd like to talk about Trump's inauguration.
So you're down to the last 30 seconds, so just looking for your closing comment.
We were all horrified to see wealthy people paying $1 million to sit behind him on that day. This bill prepares the path for that setting to happen in this country, and it horrifies me. Thank you.
Thank you for your submission, Garry. We have met time, but appreciate you making time today.
Thank you.
We're now going to welcome Alan Tapsell. Alan, I can see you up there. This is also a personal submission, so you've got 5 minutes, but feel free to leave some time for questions at the end.
Tēnā koutou. Thank you for providing me the opportunity to submit my personal views today on the Regulatory Standards Bill. Although I would like to make note that I do feel quite nervous today speaking publicly on this bill due to some of the targeted treatment to those who have spoken publicly by members of Parliament. I belong to Te Aroa and Tainui Waka, and I'm a researcher at the Herenga Waka Victoria University of Wellington. I oppose the Regulatory Standards Bill and recommend that it does not proceed. For the last few years, myself and my colleagues have been researching environmental governance and policy in Aotearoa, exploring how we can better care for our beautiful country. And a core finding in this research has been, to put quite simply, that when we work together and we honour Te Tiriti o Waitangi, there are good outcomes for all of us and for the whenua. That if we want to care for our environment, then we must also care for each other, honouring our interdependency and our interconnection, including creating a governance system that strengthens legislation and regulation to prioritise relationships and collective rights and obligations to care for each other and the environment. We found that when tikanga Māori or Te Tiriti o Waitangi is leading or influencing governance over the environment, these types of caring governance relationships are occurring and there are positive impacts for both whenua and people. All across Aotearoa, there are examples of communities taking steps to honour our unique democracy and work together. And these examples are often occurring through what we could call or refer to as Te Tiriti regulations through the RMA or the Local Government Act, where shared authority, joint management or partnership arrangements are happening, as well as consultation and cultural impact processes. This research and exploring these case studies has been really positive and hopeful. However, more change in the right direction is still required, and in our research we make recommendations for improved Te Tiriti, tikanga and environmental regulation. I'm extremely concerned that this proposed bill could harm or have unintended consequences for this positive progress for the environment, but also for all of our communities in Aotearoa to thrive into the future. This bill could potentially wield a large amount of power in our governance system, guided by principles that have not been created with proper consultation with the public or Te Tiriti or Waitangi partners. Furthermore, these principles are the very opposite to what our research found is needed for a flourishing Aotearoa. They prioritise individual rights and freedoms and corporate property over our collective rights to care for each other and the environment. These proposed principles that all legislation could potentially be weighed against look to entrench unhelpful values and legal frameworks further into our governance system and potentially block future innovative or tikanga-based legislation, policy or regulation. And this is dangerous, and there are many issues with this bill that many have already outlined, but I'm particularly concerned with three specific things. Firstly, that Te Tiriti is not referenced at all in the principles. Secondly, that good lawmaking principle states the importance of consulting to the extent that is reasonably practical, and how this might negatively impact on consultation with Māori and mana whenua in environmental contexts. And lastly, the Regulatory Standards Board and the large power it could have to inquire into legislation and respond to complaints under this bill, with its members being appointed at the discretion of the Minister for Regulation only, whereby those appointed might not have any expertise in Te Tiriti issues, environmental issues or health issues, and instead be focused on efficiency and economic growth. When we prioritise companies and individuals over our collective well-being and the environment, we all lose, and it will cost us in the future. And we're so lucky to live in such a beautiful and diverse country, and we really need to look after it together. So once again, I strongly oppose this bill and recommend it does not proceed. Thank you.
Thank you, Ellen, for your submission. You didn't come across nervous at all. You did very well. We've got a question from Cameron Luxton.
Oh, thank you, Chair. Thank you for being here, Ellen. I just have a question about in your submission you mentioned unhelpful values. Could you just tell us what those unhelpful values are?
Yeah, I mean, I think I stated them in my talk just then, but the sort of individual property rights over sort of our collective rights for the environment, as well as some of the ideas around good lawmaking that I think don't include Te Tiriti. So how is it good lawmaking when we don't have our constitution, one of our foundational documents in the law? Yeah. But
not ones that aren't then. So you're saying individual property rights is an unhelpful value. Was there any others in there that you thought were unhelpful?
Just the general neoliberal values. Yeah, all of them.
Like rule of law, human rights. No?
I think human rights are really important, obviously, but I think the lack of the value of the environment, there's no specific value for the environment and the environment's right, and the cost-benefit analysis that I see in there doesn't seem to take into account the environment as sort of something that is living and breathing.
Okay, thank you. We're a little ahead of time, so go for it.
Kia ora, morena, Alan. Just a quick question. Thank you for your presentation. Are you concerned that the bill could be used by powerful corporates and private interests to challenge or weaken Māori environmental and cultural protections?
Yeah, I guess one of the big concerns is that it could potentially limit or cause the need for increased justification for using treaty clauses or honouring those sorts of things that we already have in our law, and also limiting consultation, so companies getting around consultation with mana whenua, which often is causing good outcomes for everybody. When you consult and you work together, you can find solutions.
And do you think that Te Tiriti o Waitangi protects all of Aotearoa from corporate exploitation and international greed?
I think Te Tiriti o Waitangi has some really great values and ideas about working together to protect each other and the whenua, yeah.
Apai, kia ora.
Thank you. Thank you again for your written and oral submission, Alan. All right, we're now going to go to David McNabb with the Community Development Team of the Community of St. Luke in Remuera. Welcome, David. We've got you for 10 minutes, but of course you can talk less and save time for questions at the end if you wish.
Kia ora koutou. He honore, he kororia ki te atua, he maungarongo ki te whenua, he whakaro pai ki ngā tangata katoa. Honour and glory to God, peace on earth, goodwill to all people. Amen. E rau rangatira mā, Tēnā koutou, tēnā koutou, tēnā koutou. Greetings to the honourable members of this panel and indeed to all the listeners and people participating. I'm David McNabb, Parish Clerk and representing the Community Development Team of our St Luke's Presbyterian Church, Remuera, Newmarket, Auckland, and by profession I'm a registered social worker. Our particular group is a social justice focused group from a diverse but predominantly Pākehā congregation running across Auckland, but based in Remuera, Newmarket. Alongside our church program, we operate a community centre that is supported by Auckland Council and is home to a wide range of community organisations. We host an early childhood centre and run a community program on public issues. We are advocating that this bill is dropped in its entirety. Our first point concerns the threat of this bill to the honouring of Te Tiriti o Waitangi. For us, honouring Te Tiriti is a fundamental principle, firstly of our Presbyterian Church of Aotearoa, New Zealand, where there is a bicultural partnership with Te Aka Pōahu, the Māori Synod. We are one of many churches and faith groups seeking to honour the treaty and, of course, to become more bicultural. At the community of St Luke, we seek to honour Te Tiriti and be in partnership with Māori as well. Many of us have come to see the treaty as a covenant with a spiritual dimension, not merely a contractual arrangement in the distant past. We also see the treaty as offering hope for our common good. The church has had a major role in the signing of the treaty, and so we believe we have a responsibility to uphold it. We want the treaty to become more a part of national life, not less. Our parish recently celebrated its 150th year anniversary, so we've been around a wee while. However, it's only in recent decades that we have learned about the significance of the treaty. Back in the day, no one was talking about the treaty, no one was very interested, no one was seeing it as having any particular significance. Those of us who are Pākehā like me now see that we have a role in upholding the treaty principle of rangatiratanga for Māori and indeed an equitable society for all of us. We note the Waitangi Tribunal recommendation against the bill because of its effect on lawmaking and the issue of the ability of Māori to uphold their treaty rights. Many submitters, including this morning, have spoken against it, and we're well aligned with those views. Our second concern relates to the threat of this bill to the environment. It's lovely hearing from Alan just before, who articulated the importance of a focus on the environment for its preservation, but also as an example of what should be kept in focus. We're worried that the bill could enshrine principles where a future government, to protect the environment, is forced to compensate businesses for costs incurred. This would give an undue influence to major business interests. Our parish identifies as an eco-church, committed to doing everything we can to address our climate crisis. We are concerned that the bill would get in the way of that. Finally, we're concerned that the bill gives priority to property rights over the interests of other people and their well-being. Of course, property rights remain important and have a place. We're concerned of the undue prominence of those rights over others. This further entrenches the inequity that exists in our community and that we see around us and in the work we do. We hold to the fundamental Christian principle of loving your neighbour and doing justice. We believe we must have a focus on the interests of the less powerful and those we've even heard about in the submissions this morning, including blind, low vision, groups of people who traditionally have struggled to get their interests represented and who don't tend to have the money and other influence to promote their interests. So we want, again, more focus on addressing inequities in our community and as good a path for doing that as possible, not less. The government has prime responsibility for ensuring the well-being of the whole of society. And as I was saying, we are particularly interested in making sure the interests of the poorest and the least well represented are protected. We do not want a government to be fettered by a law that prioritises property rights over broader community interests. And I think we've got a little bit of time to finish. I want to offer a short waiata that speaks to love, faith and peace for us all. Te aroha, te whakapono, me te rangi mai e tātou tātou e. Kia ora.
Kia ora. Thank you for your submission and your waiata. We have got a minute or two if there's any questions from members. It looks like there are none. So thank you, David, for your submission. Appreciate you making the time.
Kia ora.
Kia ora. Thank you. I'd now like to welcome Georgie Dancy from Etu. Welcome, Georgie. Good to have you this morning.
Kia ora, Ryan. I also have Sharon Barton presenting with me today. Is she here?
Can't see her currently, but do you want to get underway and we can do a loop her in as she pops up?
Yeah, let her in as she comes in. Okay, well, kia ora, morena, everyone. I'm here representing Etu. Oh, here's Sharon now. Great. Representing Etu Union, and I have Sharon with me, who is our convener of Tiruranga at Etu. Etu represents over 48,000 workers in New Zealand. We're the largest private sector union. We have workers across aviation, manufacturing, communications, infrastructure, support services, and the public sector. And our members, many of whom are essential workers, stand to be directly affected by the Regulatory Standards Bill, and Etu opposes the bill in its current form. The bill poses significant risks to public well-being, democratic accountability and te tiriti o Waitangi. It prioritises corporate interests over people and entrenches inequality. The bill reframes regulation through a narrow economic lens, focusing on property rights and efficiency rather than well-being, community safety or equity. The inclusion of a fair compensation clause means that if a company claims a regulation limits their profit, they can seek taxpayer compensation. This undermines the ability of governments to act in the public interest. This means that public policies designed to reduce emissions, protect workers, or regulate health and safety could be overridden by the intent of a company. Our concern is that vulnerable workers, Māori, Pacifica, disabled people, women, and low-income earners will be the most affected because it's these groups who rely on well-crafted regulation to uphold their rights and their well-being. If we look at this bill through the recent legislation, when examining recent legislation introduced with a regulatory standard lens, we must consider the Pay Equity Amendment Act. The ability for groups of women to take a pay equity case is considerably restricted by this amendment. To explain, if a pay equity claim succeeds, the increases are constrained by the employer's ability to pay. This legislation does not address paying women equitable wages or tackling the gender pay gap by challenging disparities between male-dominated and female-dominated industries. Instead, it prioritizes corporate profitability over the wages of predominantly female workers. We also have deep concerns about the erosion of democracy within this bill. The bill gives unprecedented power to the Ministry for Regulation, who appoints the Regulatory Standards Board without cabinet oversight. There's no requirement for diverse or Māori representation and no public accountability. The board can review all current and future legislation against the bill's narrow principles, which ignores broader impacts on equity, te tiriti obligations, or human rights, that weakens Parliament's sovereignty and gives undue influence to unelected appointees and private interests. The bill contains no reference to te tiriti, no requirement for Māori engagement, and no assessment of impact on Māori communities. It fails to uphold tino rangatiratanga and would likely prevent targeted equity-focused legislation from being passed in the future. ETU urges this committee to recommend that the bill not proceed in its current form. If regulation is to be improved, it must be transparent, democratic, treaty-based, and serve the public good. Kia ora, I will pass over to Sharon to continue with our submission.
E hara I te mea Tēnā rā koutou ngā raurangatira mā, ngā mihi o tēnei o te rā. I am not a lawyer, I am not an academic, I'm not an anthropologist, I'm not an archaeologist. I'm a mokopuna o ngā iwi Waikato, me Raukawa, me Maniapoto. I am domiciled with Papa Tuanuku on my tupuna whenua in the territories of my ancestors in Nehe Nui, or otherwise known as Te Rohe Pōtai, the King Country. And I am the convener of Te Runanga o E2. The Runanga opposes this bill for a number of reasons, which I think other people have adequately expressed. The bill talks about this being a piece of legislation that will establish principles that will help make good law in Aotearoa. And as Georgie and others have mentioned, there's been no reference to Te Treaty o Waitangi. Now, if we are to have good law in this country, I would suggest, and I'm sure most people would agree with this, that good law should be tested against the obligations and responsibilities of Te Treaty o Waitangi, which gives legitimacy to the New Zealand government in Aotearoa. I'd just also like to remind us that prior to Te Treaty o Waitangi in 1835, many of our tupuna proclaimed our sovereignty in Aotearoa that was recognised by King William, Queen Victoria's father or grandfather, I'm not sure which, but her tupuna anyway. And in that declaration, they said that no entity could enact any law in this country without the express consent of confederated tribes of chiefs. Tāpai. 5 years later, as we all know, the English Crown entered into an agreement with the sovereign nations of Aotearoa. That agreement was to uphold certain promises and obligations that both parties to the agreement had agreed to. And when I think of this bill and many other pieces of legislation that has been introduced into Aotearoa, it just feels, I'm reminded of that saying, you know, a rose by any other name is still a rose. The Regulatory Standards Bill is no different to the Treaty Principles Bill that has that recently failed approval. It is no different to the pay equity legislation that was just recently introduced in May. All of these pieces of legislations serve to undermine the mana and authority of Te Tiriti o Waitangi. Other people have spoken about how this legislation serves only the interests of corporations. Well, most of the legislation in this country serves the interests of corporations.
Kuia Shannon. Sharon, we're just coming to the end of time, so I'm just wanting to, if you could maybe move towards your concluding comments.
Wrap it up. Well, I think any test of good legislation in Aotearoa needs to be measured against Te Tiriti o Waitangi, which gives the New Zealand government legitimacy in this country. Ka pai. And I strongly recommend that the bill be rejected. What else am I going to say? Oh, there's a lot more I wanted to say. But if this bill should go ahead, I would say that the New Zealand government is bordering on sedition because it is acting against the interests of the sovereign, King Charles, and against the interests of the other parties to the Treaty of Waitangi. And therefore, I suggest that this bill just be abandoned in the interest of the well-being of the peoples of Aotearoa.
Thank you, Sharon. Very clear. And thank you also, Georgie, for your submission on behalf of Etu. Appreciate it. We're now going to welcome Jeremy Finn and possibly Anne O'Brien. They're making a personal submission. Welcome.
Yeah, thank you.
To you both. We've got 5 minutes with you, but of course you've got some, if you have some time, we can have some questions at the end.
Thank you. In our submission, this bill has profound implications for the constitutional foundations of our democracy. We wish to emphasise 4 points in this brief oral submission. Firstly, in regard to the treaty, this bill provides that if enacted, it will bind the Crown. The Crown is a signatory to Te Tiriti o Waitangi, which is the foundational document of our modern society. It protects Aotearoa, New Zealand, and offers every citizen the right to belong, to share in decision-making, and to work together for the benefit of us all, and for the protection of our unique land. We note that apart from reference to treaty settlement acts and bills in clauses 5 and 10(1)(f), there is no reference to the bill to the relevance of Te Tiriti o Waitangi and the nature or scope of legislation. We consider this is unacceptable. Recognition of and consideration of the provisions of Te Tiriti should be a required design principle of all regulation. Secondly, in relation to the role of the courts, although the bill states that the legislation should preserve the court's constitutional role of ascertaining the meaning of legislation, we consider that the establishment of a regulatory standards board with the power to carry out inquiries into legislation has the potential to undermine decisions of the courts and to blur the line between the separate functions of Parliament, the executive, and the courts. And I'd now pass to Jeremy to deal with the two further key points.
Thank you. The first point I want to make concerns the clash between the executive and the legislative arms of government, which this bill will produce. The bill appears, particularly in clause 3(2)(b), to attempt to fetter the freedom of Parliament to enact legislation as it sees fit, because it's intended to require all existing and proposed legislation to conform with the principles of responsible regulation. Now, parliamentary sovereignty is the keystone of our society, and therefore it should not be subject to any kind of external constraint. Now, this may seem contrary to Section 25, which says that the failure to comply with the bill does not affect the power to make legislation, but the whole thrust of Part 2, Subpart 2, the scrutiny process in the bill, is to influence legislation. And what's more, the problem is that it's not just the executive, it's one minister who embodies the executive, because the Regulatory Standards Board is totally lacking in independence. If you look at Schedule 2 to the bill, the minister can appoint whoever he or she likes. They have no requirements of particular qualifications or knowledge, and that's a real problem if they're trying to understand what legislation means. And they can be dismissed at will by the minister. That is totally unacceptable, to have a body controlled by a member of the executive which can influence Parliament. That's just principally wrong and therefore should not be admitted. The last point that I want to make particularly is a different one. It concerns the prioritization of property rights in a very improper and dangerous manner. This is Section 8(b), with dealing with the fact that legislation should not unduly limit the rights of action of a person, except to protect liberty, freedom, or rights of another person. Now, that means not liberty of society, because that's the concern. At the moment, our law allows people to have their property rights limited if there is a greater social good. Under this bill, it has to be shown that there is one person, existing person, not a future person, who is going to be more seriously affected, so that people can dump rubbish in the river because their interest in getting rid of the rubbish is greater than the interest of people who like clean rivers. And indeed, under this rule, we wouldn't be allowed to have legislation limiting advertising of vape shops. We wouldn't be allowed to limit alcohol licenses and sales hours. Indeed, it's just wrong to prioritise the interest of property owners over society generally. So we would urge to remove the bill completely, reject it.
Thank you. We'll end on that note because we have gone over time. Thank you both for your submission.
Thank you
for the opportunity.
We've got Kevin Hague up in our panel ready to go. This is also a personal submission. Welcome, Kevin.
Morena, Ryan, morena koutou. So I want to begin by emphasising a few key points from my written submission and then to deal with some of the impacts of the bill. Having agreed to support a regulatory standards bill to improve good governance and economic efficiency, members from the National and New Zealand First parties, I'm sure, will have been surprised by the introduction of a bill that does neither. Rather than good governance, it offers confusion, bad process, and a libertarian policy filter across the whole of government action. And to the extent that it deals with economic efficiency, it uses a sixth form economics idea of what that means, equating efficiency with cost minimisation. As I've said in my written submission, the 29 men killed in the Pike River disaster are amongst many victims of the last wave of deregulation in the interest of cutting business costs. And the worst of some terrible ideas in the bill is Clause 8b. In my view, this is the purest statement of extreme libertarian values that I have seen in legislation, and I find it impossible to believe that any party except the ACT Party supports it. In fact, the whole of Clause 8 sets out a higgledy-piggledy mixture of rules for process and rules for content. And as others have said, the process rules are highly selective and mostly just unnecessarily duplicate or add complexity to rules that already exist. The rules about content cut across democratic and constitutional arrangements. The content of regulation is properly determined according to the values and policies of democratically elected governments. And it's inappropriate for one government to hinder a future one from implementing its policies. I provide in my written submission a table of this bill's compliance, or rather failure to comply, with the principles it sets out for other regulation. At one level, it's pure comedy, but it also strongly suggests that the Honourable David Seymour is not a serious person. He's not interested in better regulation. He just wants less regulation, and for what remains to conform to libertarian ideology. As for the actual effects of the bill, the first and most obvious one will be a substantial increase in bureaucracy and cost in every part of regulatory systems. Rather than economic efficiency, this bill will increase the costs of governance. The second effect will be uncertainty and confusion. The selective and altered form of many of the principles will open the door for years of litigation to understand how this has changed what is currently settled law. The next effect is a chilling one. The Minister protests that regulators won't have to follow the bill's principles, but the reality is that Parliament will have legislated a set of principles that it says regulation should comply with. Pressure from David Seymour's guidance through to action by the board to reach over and create hurdles for non-complying regulation will see compliance with the principles become the default. I note too that all of the submitters I have heard speak in favour of the bill so far have done so because they believe it will have real-world effects of removing regulations they don't like. Nobody is buying David Seymour's line that there's nothing to see here. Parliament's legislated statement of what it considers responsible regulation will also become one of the sources looked to by the courts when interpreting other statutes. It will have real-world effects even before it starts to lead to changes in black-letter law. My written submission explains the constitutional change the bill would make, shifting accountability functions from the judiciary and legislature to the executive, very much as the previous submitter indicated. And hand in hand with this is something that many submitters have mentioned, the concentration of power in the Minister for Regulation. extreme libertarian goals, but authoritarian means for achieving them, and neither should be supported by any party except ACT. All of the criticisms of earlier versions of the bill, low probability of achieving its aims, high probability of unintended consequences, little confidence that any gains will outweigh costs, constitutional change by stealth, and anti-democratic nature apply to this bill too, and it should be dumped.
Okay, we have met time, but we're just waiting on the next submitter, so I will go to Dr. Deborah Russell with a question.
Thank you, Ryan. Thank you, Chair, and thank you for your submission, Kevin. I'm looking at clause 24, and you've addressed it in passing. So that's the clause that says that the Act does not confer a legal right or impose a legal obligation on any person that is enforceable in a court of law. I've been wondering about this because the same sort of thing happens with our Bill of Rights, but it does seem to have been read into legislation. Do you have any sort of knowledge or insight into that?
Look, I don't. It's not my area of expertise, as I say in my written submission. My biggest concern around that is that by not conferring rights or responsibilities, it achieves the bill's effect of embedding that libertarian filter at the heart of government, but without doing so in a way that opens the door to judicial scrutiny. So that the effect of clause 24 is in fact to further remove the actions of the executive from scrutiny by the judiciary.
So it's interesting. I think you referenced the Eye of Sauron in your submission somewhere. Well, if it was yours or someone else's, but it feels Trojan horse to me. I'm reminded of Sir Geoffrey's memorable phrase in one of his books from the 1980s, unbridled power. And what's proposed for the Minister for Regulation is pretty close to that exact description.
Okay, thank you. Thank you for your submission. Thank you, Deborah. We have got a next submitter here, so I'll bring them up now. We've got the Royal Australasian College of Physicians, and I think it's Dr. Matt Wheeler presenting.
Tēnā koutou.
Welcome, Dr. Matt. We've got 10 minutes with you, but feel free to finish earlier to allow time for questions.
Tēnā koutou. E te tuitahi ka mihi, ka tika me mihi ki a takutau mo ana Kim ko whēturangi tia a mui mai rā e te mareikura. Today I'm speaking on behalf of the Royal Australasian College of Physicians and its Māori Health Committee. We strongly oppose the Regulatory Standards Bill of 2025. We believe this bill poses a serious threat to public health, Māori health equity, and the constitutional integrity of Aotearoa New Zealand. The RACP has a long-standing commitment to public health and health equity. We are deeply concerned that the bill's principles exclude any reference to hauora, health, well-being, and te taiao or environmental protections. It prioritises property rights over the public good, limiting the government's ability to regulate in the interest of health and equity. It ignores Te Tiriti o Waitangi, failing to uphold the Crown's obligations to Māori. This bill risks entrenching systemic inequities, particularly for Māori, and undermines decades of progress in public health regulation. We foresee very significant risks to public health in this bill. The bill's framework, particularly Clause 8, requires ministers to justify any regulation that may interfere with property rights, impose levies, or limit freedoms. Critically, the bill excludes public health, human welfare, and environmental protection from its guiding principles. It requires ministers and agencies to justify any inconsistency with Clause 8's principles, creating a chilling effect on future legislation. For context, about 80% of all health outcomes actually come from outside of traditional healthcare, which we generally call the social determinants of health. This bill will discourage or delay public health measures such as tobacco and alcohol controls, clean air laws, or housing standards. It enables commercial interests to seek compensation for regulations that protect public health and undermines efforts to address the social determinants of health. Examples of light-handed regulation already harming health include Aotearoa's damp, cold housing stock, contributing to respiratory illnesses, the rapid rise of youth vaping, and the overconsumption of unhealthy food and alcohol. As far back as 1856, Waikato and Waipa chiefs protested to the Parliament of the day. If they were not heard then, how will they be heard now if this bill were to come into law? The RACP has consistently supported regulatory measures that reduce harms and relieve pressures on our overstretched health system. The bill would make such measures harder to implement at the overall cost of our society. The Regulatory Standards Bill's failure to reference Te Tiriti o Waitangi or Māori rights is not just a symbolic omission, it has practical and harmful consequences for Māori health and well-being. Clause 8's narrow set of principles prioritise individual and corporate interests, not collective well-being. There is plenty of evidence for targeting services for Māori. It is evidence-based, and the treaty gives it special status to do so as well. If we can't get it right now, then adding the impact of liberty, security of property rights will not help this. For Māori, regulations that protect whenua, the land, wai, water, and tūranga waiwai, their home place, essential to Māori identity and health, could be weakened or blocked. Efforts to improve housing standards, reduce tobacco and alcohol harm, or regulate unhealthy food environments could be challenged as inconsistent with those property rights. The government's ability to respond to systemic health inequities, such as the 7 to 8 year life expectancy gap between Māori and non-Māori, we believe would be severely constrained. This bill follows a disturbing trend, including the disestablishment of Te Aka Whaiora in 2024, which dismantled a treaty-based approach to Māori health leadership. It entrenches a model of government that ignores Māori values, undermines tino rangatiratanga, and prioritises corporate profit over Indigenous well-being. We consistently say in health that if you get it right for Māori, you get it right for all. A culturally safe and responsive health system is safe for Asian, Indian, Black, White, Rainbow. This bill is in contradiction to that, as not everyone has the intergenerational wealth, and by that I mean intellectual wealth as well, to prosper in the society. This bill, we believe, will make it impossible to push that needle as health professionals try to design safe and effective systems to improve people's lives and outcomes. Walk a week in my shoes and you would see the true effect that intergenerational trauma has caused. Only by lifting those less fortunate up will our society truly prosper as one. I had a 37-year-old Māori man see me the other day. He had the heart of an 80-year-old, but just thought he had asthma. Trying to implement health reforms for him may find that the cost outweighs the benefit, but for him no amount of cost can compare to what has been done for him now. How can we as a society allow this type of lawmaking influence how our healthcare is delivered? We are not asking for Te Resi to be added to this bill. We are asking for this bill to be scrapped entirely. The bill also disregards He Whakaputunga o Te Rangatiratanga o Nuterini, the UN Declaration of Rights of Indigenous Peoples, and the Mātiki Mai report, which outlines a vision for constitutional transformation grounded in tikanga, inclusion, and relational government. Mātiki Mai calls for a future where Māori and the Crown co-govern based on mutual respect. This bill entrenches a Western, individualistic, legal framework that prioritises private property over collective well-being, directly contradicting Mātiki Mai's principles. This is entirely inappropriate for ensuring Māori health and equity. To ensure Māori health and equity, we need fair and proper consultation with Māori. This has just not occurred. The Waitangi Tribunal's interim report on the Regulation Standards Bill, Y3470, released in May 2025, provides a clear and urgent warning about the bill's constitutional and treaty implications. The Tribunal found that the Crown failed to consult Māori in good faith during the development of the bill, breaching the treaty principles of partnership and active protection. The bill, if enacted without meaningful engagement, would constitute a breach in Te Reti o Waitangi, particularly because it seeks to influence how Parliament makes law, an inherently constitutional matter that directly affects Māori. The absence of consultation has already caused prejudice to Māori, including stress, uncertainty, and damage to Crown-Māori relationships, which is critical to ensuring Māori health and equity. For us in health, we would never go through to try and integrate any sort of health reform without first asking the people who this would influence. And this has clearly shown that this hasn't happened with this bill. While the Regulatory Standards Bill claims to strengthen New Zealand's legal and governance framework, it starkly contradicts several existing laws and public health commitments that explicitly recognise Te Reo Waitangi and the need to address Māori health inequities. For example, the Paiora Act 2022 requires Health New Zealand to maintain systems that understand and respond to Te Reo Waitangi, kaupapa Māori services, cultural safety, mātanga Māori, and Māori perspectives on health services. Similarly, the Ministry of Health's Te Reo Waitangi framework outlines foundational goals such as mana whakahaere, mana motuhaki, mana tangata, and mana Māori. These frameworks are designed to uphold the Crown's obligation under Te Tiriti and to actively protect Māori health and well-being. Yet the Regulatory Standards Bill makes no reference to this, ignores Māori rights and interests, and prioritises property rights and commercial interests over collective health and well-being. We urge the subcommittee to reject the Regulatory Standards Bill. We call for a Tiriti-based health impact assessment guided by the principles of Mātiki Mai and meaningful consultation with Māori health leaders and iwi. Legislation must hold equity, justice, and Te Reo Waitangi, not entrench corporate privilege at the expense of public health and Indigenous well-being. We're not asking for Te Reti to be added to this bill. We're asking for this bill to be scrapped entirely. There are other ways to do this. The RACP stands firmly against any legislative framework that compromises the health and rights of Māori and public health generally. We ask to protect the integrity of our public health system and honour its obligations to tangata whenua. With that, I'm happy to take any questions.
Thank you, Dr. Matt. There doesn't appear to be any questions for you. Yes, Dr. Deborah Russell.
Oh, I just want to say thank you for that fantastic submission. It was really powerful, and I appreciate you and the college making the time to put it together and present it to us.
Thank you.
Okay, all right. Well, thanks for coming in. We appreciate your oral and written submission. We are now going to go to KiwiPulse. We've got Tura Copa Miapuna, I think, presenting.
Hi. Kia ora koutou.
Welcome. And we've got you for 10 minutes, but feel free to finish early to allow a bit of time for questions.
Ka pai. Tēnā koutou. My name is Tura Copa Miapuna. I'm here today on behalf of Te Kāhuiraronga. I lead the Independent Trust. Te Kāhuiraronga, under the mandate of the Data Iwi Leaders Group, was established in 2019 to lead the action required to realise the aspirations of iwi Māori through the advocacy of the Data Iwi Leaders Group. Our goal is to enhance the social, cultural, environmental and economic well-being of Māori, to enable iwi, hapu and whānau Māori to access, to collect and to use our own data. It is with this lens that we considered the implications of the Regulatory Standards Bill on iwi Māori. I want to be very clear, Te Kāhuiraronga has examined the Regulatory Standards Bill in detail and we strongly oppose this bill. In fact, we urge you to withdraw the bill in its entirety. The Regulatory Standards Bill fundamentally fails to uphold Te Tiriti o Waitangi. It disregards the collective rights and aspirations of iwi Māori and prioritises private property and corporate interests over public good, environmental protection and the well-being of iwi Māori. I know that in our written submission, we've made some clear points around why we oppose the bill, and I have seen some really beautiful articulation by many other submitters before me. So I do want to probably just take this time to make two clear points with respect to data that connect to our written submission, but I just want to emphasise. And so the two really key points for me, for us, are that this bill privileges the rights of individuals and corporates and omits the rights of collectives, which will have a negative and long-term impact with respect to the data landscape of this nation. Secondly, it puts at risk the very delicate social licence of trust that our nation has of its own data system. And, you know, as we've talked about in our written submission, we published a globally leading Māori data governance framework that is our aspiration for a Te Tiriti-led data system, bringing a collective lens and the understanding of the importance of collective rights to data. It was so globally leading that we were invited to the International Conference on Machine Learning. 40-year, 10,000 strong machine learning community to sit on the stage with the likes of Microsoft and Meta or Facebook, Apple, and many others who have been leading this space, the artificial intelligence and generative artificial intelligence space for many years, because they recognized the need for this collective lens, the need for the understanding around the importance of collective rights and the values and ethics that are embedded within this global model and data governance model. And what it really shows is that there is a deep intelligence in this nation around how we balance and recognize the rights of individuals and the rights of collectives, and how important that is in the future landscape and in the future ecosystem for data. There is a real embedded mātauranga Māori that our nation is founded on that puts us in good stead for an area that is only but growing. And I want to be clear, data is not only a strategic asset and what we know to be probably the biggest commercial asset in the world, it is a national asset for New Zealand. And what we recognise is this bill puts at jeopardy that national asset. I guess lastly, the key points I want to make is that this bill fails to honour Te Tiriti principles of partnership and participation. Even the way that the bill was crafted was in isolation of Te Tiriti partners. As I said, it prioritises the property rights of individuals over the collective rights, and it will have ultimate impact on the protection of our environment and the protection of our data and digital ecosystem going forward. It reflects the values of and priorities of a very small number of New Zealanders, and I think as a nation we've got greater aspirations for ourselves than this. So we join the call for the halt of this bill and call for a deep Te Tiriti-based review and exemptions to safeguard Māori interests before any further parliamentary progress. I'm going to leave it there. I see that there's already a hand raised for questions, but just allow the time for any questions that there might be from the committee.
Fantastic. Thank you. Yes, we'll go to Dr. Deborah Russell.
Thank you, Mr. Chair. Kia kouwhai, thank you for this submission, and thank you for bringing your expertise to this. I know you're one of the leading people in this space around data sovereignty and Māori data sovereignty, and I really got to grips with that model and tried to get to grips with it when I was Minister of Statistics in the last government. So thank you for your mahi in this space. I just want to go to clause 24 of the bill. It's got me worried because it's the one that the Minister is relying on to say that the bill is kind of not going to do anything in particular. It says that the Act does not confer a legal right or impose a legal obligation on any person that is enforceable in a court of law. Do you see that as a realistic claim that's being made, that the bill therefore doesn't have any effect because nothing's enforceable in a court of law?
No, not at all. I think that, well, we believe it's incorrect. I think it will have a direct impact. And as I said, I think it will have a long-term negative impact, particularly in the space that we work in. I think whilst it might say that, I mean, the biggest issue for us is the omission of particular understandings around the collective rights. So, no, I would strongly disagree with that.
Yeah, and just thank you. And talking in that space of collective rights as well, and directing your attention back to clause 8, and that's where it talks about liberties. I feel as though it's a very individualistic view of liberty sitting in there. Do you have any views on that?
Definitely. I mean, as I said before, I think, you know, one of the real beauties of our country is we have this deep intelligence about how we have for many generations, because of our founding document, been able to navigate the understanding of individual lens and collective lens, individual rights and collective rights. And I think what we see here in the clause 8 that you've pointed out is that there is a misunderstanding of you know, the benefit of that deep intelligence that we have.
Okay, thank you.
Thank you. We've got a question from Maria Mino Kapikingi.
Thank you, Mr. Chair. Morena, e kiri ko whai tēnā ro hoki koe tēnā tātou. I mean, you were in the House the other day in presenting to a number, which was an all-around AI and all-around data, which in our view, and I'm sure in yours is ultimately it is about people. And in this regard then, comparing what I'm hearing and consistently when this bill was originally put is it came off the back of the Treaty Principles Bill, and that was a big fat no. So now, but this was considered and talked about as the ugly sister, or just as dangerous, if not more so. You got any comments to that point of view? Because that's certainly what's running in the Māori quarter. So interested to hear what your view is on that.
Yes, I mean, firstly, we were privileged to be invited to present to the AI caucus, cross-party caucus the other week, where we came to talk about, I guess, the recognised risks of just adopting particular technologies and individualistic lenses with respect to the future of data and artificial intelligence. And then, as we talked about, one of the real opportunities that exists in this space for us to lead in this space, not just follow, is that it be based on the principles and the values that we have in our nation that come from our founding document. And so when there is any challenge and maybe short-sighted challenge to the principles, to the values, to te tiriti o Waitangi, that is ultimately the reason why we've made this submission, because we can see the connection, we can see the risk, and not just the risk to the rights that we have and have inherently always had, but to the opportunities that we have as a nation to get better outcomes for our people.
Thank you. All right, I appreciate your time, Kiri Kowhai, coming in, and your verbal and written submission. We're now going to go to the Taxpayers Union, which I believe are in the flesh in the Select Committee room. So welcoming to the table, we've got Jordan Williams, James Ross, and Ray Deakin, I believe.
Good morning, Mr. Chair. I think we are both virtual and in real life.
Okay, the hybrid. Welcome. We've got you. You know the drill. We've got you for 10 minutes, but please leave some time for questions.
Thank you very much, Mr. Chair. My name is Jordan Williams. I'm the co-founder and executive director of the New Zealand Taxpayers Union. My colleagues who are in the room, James Ross, our head of policy, public affairs advocacy, and Ray Deakin, who I know many of you will know, our economist. It's very clear, according to various international organisations, that New Zealand's poor quality regulations is one thing that holds New Zealand's economy and our standards of living back. And this bill, quite frankly, we consider a litmus test on whether the government is serious about getting New Zealand back into the status of a first world economy and with first world living standards. It's too easy for us, and we can spend the time taking on some of the more ridiculous assertions and frankly hyperbole that have been bantied about this bill. But I mean, ultimately it comes down to the political parties and you as MPs to choose whether you want to be adults and take a long-term view and back New Zealand, or take a short-term political slapsticks that frankly keep New Zealand poor. In the same way as, the Taxpayers Union, we pick up ideas where they're good from the Greens, particularly around transparency. For example, we think that this is on the other end. This bill is primarily around transparency, and it's around transparency is something the Taxpayers Union really cares about, and that is regulatory tax and regulatory taking. It goes at least some way of identifying costs of regulatory taxes. The bill is in effect an information disclosure regime. It does not obviously tie the hands of Parliament, other than forcing lawmakers to turn their minds to cost trade-offs and regulatory takings, among other things. It is, and I say this in my background in public law, an encapsulation of what used to be seen as just good lawmaking, And I put to you, for example, one of your key roles as an MP is to uphold the rule of law. Frankly, if you vote against a bill that requires disclosure of the rule of law implications of proposed legislation, I'd put to you that that is a failing of what is traditionally a duty of being a public representative in Parliament. I'll hand now over to Ray, who drafted our submission, to go into a bit more detail.
Thank you, Jordan. Good morning, members. The economic cost of poor legislation is enormous. In 2014, the Productivity Commission found that nearly 2/3 of New Zealand's regulatory agencies were working with legislation that was outdated or not fit for purpose. We do not recall that this prompted urgent government corrective action. The New Zealand Initiative, who are on tour in the Netherlands at the moment, report that the Dutch realised poor legislation was creating a drag on their economy. Corrective action resulted in a 25% reduction in the administrative burden within 4 years. This liberated €4 billion annually. Even a modest improvement in the quality of legislation represents a dramatic saving in economic cost that will be far in excess of the cost of the regime. But there has been no plan to assess the quality of legislation. There has been no plan to improve the quality of legislation. Therefore, there has been no plan to reduce the economic cost of redundant, ineffective, or poorly implemented regulation. There is only an ad hoc approach to reviewing and amending legislation, and even then, this usually only occurs when it is impossible to ignore the cost of regulatory failure, until this bill. As well as assessing the quality of developing legislation, this bill provides the legal structure for assessing the quality of existing legislation. This has to be worth something.
Thank you. Is that the conclusion of your submission, gentlemen?
Oh, I just want to go through very briefly what the bill does and doesn't do.
Okay.
This bill is information disclosure for legislation. It is purely an information bill, nothing more and nothing less. It provides a public check on the quality of legislation by assessing it against fundamental common law principles. These principles are the foundation of our legal system and have been developed over centuries. Explanations are required when legislation deviates from these principles. This promotes transparency. Transparency promotes accountability. One of the most important provisions is the ex post analysis of legislation that is passed in haste, either under urgency or in response to actual emergency. Scrutiny, transparency, and accountability cannot be avoided. This bill provides much more public information about legislation, both existing and in development, and this extra transparency will promote better legislation and better government. What the bill does not do, the bill does not compel compliance with the principles, invalidate non-compliant legislation, confer rights or obligations enforceable or in a court of law, and favour specific ideologies. This bill does not override existing legislation and does not compel new legislation to be developed in a certain way. That's the end of our presentation. Thank you.
Thank you. I might just kick off and then I'll go to Francisco. We've had a lot of submitters in opposition to the bill and a lot reference the treaty or te tiriti. To me, some of it seems like there's all this opposition to the bill, but it's almost like there's a mismatch, there's a misunderstanding of what the bill tries to do versus the perceived risk. Why do you think there's so much misalignment in terms of submission or opposition to the proposed bill?
Because it's ACT. Because it's off the back of a very contentious bill. It was Treaty Principles Bill. I mean, it's that simple. I mean, the bill doesn't offend the treaty, but it's been hijacked by a campaign that piggybacks off an earlier campaign of a bill that reasonable minds can differ on treaty principles. That's fine, but it seems that that particular political interests have a hammer, and now all they see is nails. I mean, a lot of the treaty stuff is frankly just a lot of disinformation and rhetoric. It's about identifying costs. It doesn't offend the treaty. You could argue that there could be treaty things included, and obviously many people have, but that's actually not what the bill is about. I'm not at all convinced. I've not seen any arguments that would suggest that it is inherently. How is information disclosure about the costs of legislation against the treaty? That's the fundamental question.
If I could add a few things. This is the fourth attempt at introducing a bill like this in the last 20 years. So it's not new. It's been around for a while. But I'd like to make a few points about Te Tiriti. And this is my summary of Dr. Bryce Wilkinson's submission, which makes some very, very good points in his Q&A section of the submission. The bill focuses on regulatory quality and not treaty obligations. The question has to be asked, what protections are missing from the bill due to the absence of treaty principles? Nothing in the bill prohibits Parliament from passing any measures it likes. Nothing in it obliges it to fail to comply with Treaty of Waitangi obligations. And the last question, what is the problem with the principles in the bill that adding the treaty principles clause would avoid? And Bryce has not heard any response to any of those questions, neither have we. So as Jordan points out, it's extremely surprising at all of these objections.
Okay, thank you. I'll go now to Francisco Hernandez.
Thank you, Chair. I had a couple of questions, but since there's other people that want to ask questions, I'll just ask one. Thank you for your submission, Jordan and the Taxpayers Union. Out of a scale of 1 to 10, how important is it to the Taxpayers Union that the regulatory standards bill pass?
I think that it will be, and that's why I say it's a litmus test on whether this government is serious about reform. I put it up there in significance as the new RMA. I think this government is clearly not a reforming government of the type that we saw in the late 80s or early 90s. On the fiscal stuff, it's a disaster. We're borrowing more, we're spending more than the last government. And on many of the matters that it was elected on, it's slow walking. We've been very open that if the government is successful in getting the RMA, which is obviously our largest regulatory tax, out of the way and get that handbrake off New Zealand's long-term prosperity, it will be remembered for that. I think that this is, if it is embedded, and by that's really up to Dr. Russell and her colleagues, whether it is kept and it becomes normal, just like BORA disclosure is, where parliamentarians must turn their mind to the costs of all the takings contained in legislation. I think that it is quite not revolutionary. I'd put it on the same sort of basis as Ruth Richardson's Fiscal Responsibility Act, for which was and is world leading.
Okay, members, we are over time, but we're slightly ahead of time, so I will go to the next two questions. So we've got Cameron Luxton, followed by Dr. Deborah Russell.
Yeah, thank you, Chair, and thank you, Jordan, for that, putting that bill in context with BORA and Public Finance Act. I just had a question. This committee's had a couple of contributions heard where people question whether Section 24, in which the Act does not confer a legal right to impose a legal obligation on any person that is enforceable in a court of law. We've heard some submissions suggesting that the courts might ignore that provision and perhaps start having an obligation that is enforceable. Could you speak to whether that is fear-mongering, misinformation?
You've got a bigger problem then. You've got a bigger problem. There's quite an irony if you've got people coming in saying this breaches parliamentary sovereignty, and one of their arguments is that parliaments might breach that parliamentary sovereignty.
Well, it's more that the courts might take the ball and run with it and start ignoring that provision. Do you think that is a possibility?
Well, it's always a possibility, but that would be obviously right for Parliament to. That would be a constitutional crisis. If you're asking, does this invite a constitutional crisis? I don't think it does, in the same way as you look, if anything, courts have been rather restrained on BORA. Look at the way, surely the biggest BORA case in my lifetime was whether the decision to lock down in the various COVID provisions were lawful, and yet the courts bottled it. My profession slow walked it.
Okay, thank you. Dr. Deborah Russell.
I just want to, it was a bit of hyperbole there, really, around that, but let's just pass on that. I just want to clarify that the thing was not so much whether the courts would enforce it as that they'd start to read the principles into various other cases that are in front of them.
But that's already the case. You look at the principle around that taxes and levies must be, that there's not, the executive doesn't have the power to tax, only Parliament can tax. The courts already apply the standard rule of law principle that the ability to tax must be very explicit in legislation. This is the thing, that these principles are not radical. They are classical Westminster style, not just principles of good lawmaking, but principles of good legal interpretation.
Okay, I disagree around that. I'll test that with some lawyers and other lawyers later on. Look, I want to say that you wanted, you said that there was no ideology embedded in this bill, or one of the, I'm not sure exactly which one of you three said it. But looking at clause 8, I just see that as straight out libertarian philosophy. How can you say there's no ideology embedded in this bill when it has this very individualistic view of what liberty is, and a very much a prioritizing of property rights over all other rights? That's just pure libertarian ideology.
Well, transparency, it doesn't enforce it. It requires identification of costs and the transparency of it.
Right, but it does, to say it's non-ideological is just frankly wrong. It does have an ideology.
Well, unless you're saying, Dr. Russell, which I'm sure you're not, that your particular ideology ignores the costs Parliament imposes on people.
No, I'm saying that clause 8 embeds libertarian ideology in this bill.
Okay, I think we've asked and answered.
Okay.
Yeah. All right. Thank you, Jordan and team, for your written and oral submission today. Really appreciate it.
Thank you, Mr. Chair.
Thank you very much. And committee, thank you very much for hearing us.
All right, we're going to go now to a personal submission from Aaron Hawkins, who I believe is up with us in the panel.
There we go.
Welcome, Aaron.
Kia ora.
Kia ora. You've got 5 minutes, but of course you can leave a little bit of time at the end for questions if you like.
Yeah, thank you. Kia ora, Mr. Chairman. Tēnā tātou katoa, and thanks for the opportunity to speak to the Select Committee this morning, a privilege that appears to be afforded to fewer people each time we engage in these processes. I'd also like to thank the lawyers and academics and my fellow recovering politicians who have done the hard yards on a clause-by-clause basis, tackling what this means for our Parliament. I recommend that it be rejected in its entirety. No amount of tinkering by way of amendment can save this bill from itself. A lot of how our democracy works is grounded in convention rather than legislation. And the premise of the Select Committee is that legislation is proposed, then the public get to have their say. The parliamentarians or the government get to sit there and take their lumps. That's part of the price of their privilege. It's been appalling to see our chair leaders of this bill, our Deputy Prime Minister no less, orchestrate a coordinated attack on opponents who have dared to engage in one of the only opportunities we have to question the most powerful executive in the Westminster system. But ultimately, Mr. Seymour's attacks leave me confused, because either this bill is necessary to shape all of our legislation coming through the House, as he says, or it's nothing for us to be afraid of, as he also says, because it can't be both. There's a deep irony to me that advocates of a more efficient public service are also proposing this as the solution to a problem that doesn't exist. Establishing a standing body to provide advice to the government in line with a particular set of values and principles, entrenching our existing structural inequities along the way. Because having failed to redefine Te Tiriti o Waitangi, the next best option, it seems, is to simply ignore it. But ultimately, we have to ask the question, why? Why do we need to spend the kind of money it would take to establish a body solely to make sure that the perspective of those who privilege private property rights are represented in the legislative process? The previous submitter is among many individuals and organisations who have and will continue to present that view to committees such as this one. Surely those views should have their ability to influence lawmaking determined by the strength of their arguments. Surely they don't need an additional thumb on the scale, to quote Dr. Eddie Clark, a guaranteed voice in decision-making, no matter how few New Zealanders subscribe to this doctrinaire approach. Surely the Regulatory Standards Bill can't simply be DEI for libertarians, a Greek chorus for absolute individualism, when we know that what we need to address our biggest challenges, be they social, cultural, environmental, or economic, are collective responses. We don't need further barriers put in the way of climate action, or economic nationalism, or totality justice, and members of this committee or their respective caucuses or party memberships may not support each of those things, or indeed any of those things. But they should be able to agree that they can rise and fall as part of the democratic process under their own steam. Best case scenario, this bill is unnecessary waste. Worst case scenario, it lets a fringe political worldview out of step with the overwhelming majority of New Zealanders, constrain the ability of governments to make future-focused decisions in our collective best interests. And personally, I don't take the view that others have taken in terms of the extremity of it, but I still can't find a single point along that spectrum that would make this legislation worth supporting in its current form. Thank you for the opportunity to speak.
Thank you, Aaron. We've probably got time for one question if there is one. Doesn't appear to be. So
Yes,
thank you for taking the time. We've now got our final submission before a short break from Donna Awatere Huata. Welcome, Donna. If you could just put on your camera and take off your audio, you'll be good to go.
Sorry. All good?
Hi, welcome. Yes, we can hear you. Are you able to put your video on, Donna?
Video. Yes. Sorry.
We can't see you, but that's not the end of the world. We can hear you.
Thank you. I'm a founding member of ACT, formed after the fire sale of assets built and owned by we the people, and now owned by they the wealthy, they the corporate, and they from overseas. ACT was formed, I believed at the time, to fix the gutting of the common good by Rogernomics and to undo the social cruelty of Ruth Richardson's brutal austerity agenda. Whether deluded or misled, I was wrong. Before 1984, we had our problems, including wall-to-wall racism, but massive inequity as we know it today, child poverty, homelessness, widespread mental distress were not among them. Most families had secure housing, work, access to the best health care, access to free tertiary education, and dignified support when out of work. The 1852 New Zealand Constitution Act blindsided Māori, a direct transplant of the British Constitution, its purpose to extinguish Māori sovereignty, take our lands and waters by any means necessary, including waging war, making land theft legal, and genocide. And now we're blindsided once again. Our constitution, reshaped over the generations in the spirit of Manaakitanga and Michael Joseph Savage, hijacked by the 84 and 1990 governments. Neither campaigned on a neoliberal constitutional seizure. The 84 Labour government campaigned on competence and fairness, not mass deregulation, asset sales, benefit cuts, or user pays health and education. The 1990 National Government campaigned on a decent society, not on slashing welfare, smashing workers' rights, and introducing market rents that doubled state housing rentals. The backlash gave us MMP. 4 laws from those 2 governments have ripped apart our collective strength. State Sector Act turned our public service into a business. Reserve Bank Act said inflation matters more than jobs, more than housing, more than food on the table, more than anything. Public Finance Act made our children invisible unless they could be turned into an output. Fiscal Responsibility Act made caring a liability. These laws have got to go. They are not neutral. They slashed jobs without a single thought of the devastation to families, pushed us into unsaved homes, or worse, into cars or the streets. They gouged fairness and equality, tore the spirit from our public life, recreating the misery and hatred of the poor of 19th century Britain. They've pushed the rights of polluters over the rights of the environment, ensuring the piss-pot mentality of 19th century Britain of throwing their feces into the streets and diverting filth into rivers continues, creating undrinkable, toxic waters hazardous to biodiversity to this day. This bill will take the economic dogma that caused this harm and elevate it into constitutional doctrine. It would make it almost impossible to rebuild, to fix the broken systems, to honour te tiriti o Waitangi, to reweave tikanga into public life. It would allow courts to override our voices, your voice, my voice, the voice of community, of collective care. But this bill also represents an opportunity, another backlash moment, a chance to start a conversation with one another, to build a constitution that is fit for purpose, that rejects the white supremacy of 1852 and the miserable greed of 84 and 90 enshrined now in our current constitution. What we who love and call this place our home want is simple: a safe haven for our children, people before profit and austerity, a fair tax system, and an environment honoured as the source of our well-being. It is our birthright to have those principles embedded in our constitution, for we are Aotearoa and Aotearoa is us. Whānau, whānau, haramai te toki, haumi e, hui e, tai ki e.
Kia ora, Donna. Thank you for that submission. I appreciate you taking the time. We have met time now, so members, we will break until 10:40. Just make sure you're on about 10:39. Be fantastic. We're going to be hearing from Migrants Against the Acceptable Standard of Health Aotearoa. I'm just not sure how to pronounce your name.
Anya.
Anya, welcome. We've got you for 10 minutes, but of course you can finish a little bit early, and that will allow time for questions if you like.
Kia ora, can you hear me okay?
We can, perfect. So in your hands.
Yeah. Tēnā koutou katoa. I'm here submitting on behalf of Migrants Against the Acceptable Standard of Health Aotearoa, or MARSHA. We are a grassroots migrant collective campaigning to end disability and health discrimination in Aotearoa New Zealand's immigration system by getting rid of the acceptable standard of health immigration requirements, and we are guided by migrants, refugees, and families directly affected by this discrimination. We are here under the korowai of He Whakaputanga and especially Te Tiriti o Waitangi, and we oppose the Regulatory Standards Bill. It goes against everything we stand for, and we want to explain this under two connected points. The first is that the discrimination we face comes from entrenched ableism and colonialism, and the Regulatory Standards Bill will entrench these ideologies even further at an intergenerational level. The second point is that disabled immigrants and our families know what happens without human rights protections, and the Regulatory Standards Bill will erode those protections for everyone. So to explain the first point, if we go back to the signing of Te Tiriti in 1840, at that time we could have created an immigration system based on Māori tikanga, under the work of Aramarata, Tahu Kukutai and others, using values like manakitanga and utu to guide our immigration protocols, but we didn't get that. Instead, in the late 1800s, it became very apparent that British colonizers viewed disabled people and people with mental health conditions as expensive, costly burdens. They charged ship captains for bringing disabled people into the country. And as one New Zealand newspaper put it at the time, the Dominion has been made a dumping ground for too many of the physically and mentally unfit of the motherland. In the 20th century, we saw the rise of institutionalization and eugenics. And today, we consider that the acceptable standard of health immigration discrimination is a present-day form of eugenics. It basically says that if you, as a disabled immigrant or one with a health condition, cost too much or are deemed to cost too much, you are not welcome here. Very, very difficult to get a visa. And this also impacts on disabled children of immigrant families as well. So like this immigration discrimination, the Regulatory Standards Bill sets out that supposedly good lawmaking should privilege economic value above all else. So it will entrench this discrimination. We, on the other hand, believe that every human being has inherent intrinsic value. So onto my second point, the lack of national human rights protections we have for immigrants at the moment under the Migration Act explicitly bars human rights considerations in immigration discrimination and enables this policy. So just to explain what this impacts of this discrimination actually look like, massive amounts of financial distress, relationship strains, being left in limbo for years, parents getting separated across borders from their disabled children, forced to put children in situations of domestic violence. One of our members said that the mental distress of dealing with this was worse than becoming paralyzed. And another almost withdrew from life-saving cancer treatment as the impact of the fear and distress of the acceptable standard of health made them suicidal. And this is the result of not having these human rights protections for migrants, and the Regulatory Standards Bill will deprioritize human rights protections for everyone. One other note on that is that we do still have the international law human rights protections under conventions such as the UN Convention on the Rights of Persons with Disabilities. The committee reviewing New Zealand under this convention told or recommended that these immigration requirements be stopped. The government ignored this, and the Regulatory Standards Bill flies in the face of all of the international human rights law we have signed up to. So to recap my 2 key points, the discrimination we face comes from entrenched ableism and colonialism, and the RSB will entrench that for generations, and disabled immigrants and our families know what happens without human rights protections. The RSB will erode those for everyone. So I speak now specifically to the National and New Zealand First members of the committee. I know what the National and ACT Coalition Agreement says. I know taking a stand on this bill might make the government fall apart. Please do so anyway. The impact of this bill will be intergenerational, and in Marsha, we know how hard it is to shift intergenerational harm. So please listen to the Waitangi Tribunal, listen to marginalised communities, listen to all the lawyers who've said clearly that this bill is the antithesis of good lawmaking. Thank you, and I'm happy to take questions.
Thank you, Anya. Very clear submission. It doesn't appear to be any questions. Oh, yes, we've got one from Ricardo Menendez March.
Good, Anya. Thank you so much for your submission and the points that you have raised. What are some of the values that you would instead like to see embedded in good lawmaking instead of what we have in front of us?
Thank you for the question, Ricardo. I'd like to see human rights be foundational. I'd like to see a basis in te tiriti be non-negotiable. The Matiki Mai report was a really good standing point on a set of values, understanding, community, place, balance, and all the rest of those. Just the importance of marginalized communities being at the center of our decisions, and understanding the leadership and wisdom and expertise of those who would be most impacted by harm, and just fundamentally the importance of basic rights like everyone having economic security, ending the huge wealth inequities, and also protections for te taiao. Yeah.
Thank you.
Fantastic. All right. Thanks. Thank you for that, Anya. I appreciate you making the time today. We're going to go straight to Pacific Panthers with Tiao Pritchard presenting. They're just moving online. Here we go. Welcome, and we've got you for 10 minutes, but of course you can leave some time for questions at the end if you'd like.
Talofa lava, tēnā koutou katoa. My name is Te Ao Pritchard, and I stand here as a member of Pacific Panthers. I acknowledge our written submission has been ready. I mihi to those who have already submitted and those still to come. What follows is our oral submission in opposition to the Regulatory Standards Bill. We, the Pacific Panthers, are ainga and whānau across Aotearoa and Te Moana Nui a Kiwa, woven together through whakapapa, resistance and shared responsibilities to whenua, moana and each other. We are tangata whenua and tangata moana. We speak collectively as future ancestors, as protectors of tino rangatiratanga, and as allies in the fight against this dismantling of Indigenous rights. We are making this clear. We are here to oppose the Regulatory Standards Bill, and we oppose it entirely. We stand before this committee in deep frustration, but also with fierce clarity. This bill is not just flawed, it is dangerous. It threatens democratic accountability, environmental protection, and Indigenous rights. It undermines te tiriti o Waitangi. It erodes the hard-fought gains of Māori, Pacific, and other marginalised communities. In the process, an insult to democracy. Because submissions closed and hearings barely began 2 weeks later, only 30 hours are allocated for oral submissions. That's barely more than a day and a night. A time limit so tight that thousands of voices have already been shut out. Have been made. Its compliance by force of process. We are hopeful that this committee will hear us and that the thousands who oppose this bill will be heard, but our trust in this process is on thin ice. The bill is the Treaty Principles Bill 2.0, cloaked in regulatory language and delivered by a minister with an ideological mission. The bill erases te tiriti o Waitangi from legislation decision-making. It strips tangata whenua of partnership and denotes us to observers on our own land. Te tiriti is not historical, it's not symbolic, it is constitutional. And any bill that seeks to erase it is not reform, it's regression. We call it what it is, a corporate Trojan horse, a bill that elevates unelected boards over community voices, prioritising shareholder interests while silencing those most impacted. The bill is cut from the same cloth. It bakes climate injustice into legislation. We also want to call out David Seymour's tactics, public harassment of academics, undermining of critics, and policies that treat whakapapa as an inconvenience. His backing of this bill is not policy neutral. It's a calculated part of a larger project, one designed to dismantle Indigenous rights and entrench a neoliberal whitewashed framework of governance. Let's be cautious but clear. David Seymour may not have literally said whakapapa is a barrier, but his actions and policies have consistently treated it as one. When Seymour mocks academics, dismisses experts, and labels resistance as misinformation, he's not just being provocative. He's laying the groundwork for this bill. The RSB is not neutral, it's an ACT Party manifesto in legislative form. This is not about making better laws. This is about who gets to make them and who they serve. An unelected regulatory standards board appointed by the minister will hold unprecedented power to review and challenge legislation. That's not neutral, that's structural capture. This isn't motel room justice anymore, it's boardroom justice, laws designed behind closed doors for those already in power. The bill places economic efficiency above environmental protection. We know that the government is funding polluters, even as it strips protections from land, waterways and ecosystems. This is climate denial written in legislative language. The bill ignores the lived realities of Māori, Pacific peoples and working class communities across Aotearoa. It assumes we are all on an equal playing field, while some hold megaphones and others are denied even a microphone. If passed, the bill will entrench inequality, erode local voice and remove the power of community to protect what matters most. We bring with us the lessons of our submission against the Treaty's Principles Bill. What the bill tried to do openly, this one does quietly. Both are grounded in the same logic, to redefine te tiriti so that it no longer holds any real power, to privilege personal liberty over collective well-being, to shrink the role of hapu and iwi in law and replace it with individualism, commodification and market rule. This is why we are speaking again, because these attacks are coordinated and so is our resistance. This is a season of matariki, a time to reflect, to mourn and to plant seeds for a new year. And stopping this bill is a high aspiration that we place into the soil of our collective future. We do not want to carry this bill forward into the next year, into the next generation. We acknowledge that New Zealand First, and particularly Winston Peters, have positioned themselves as open to revision, stating that the Regulatory Standards Bill is a work in progress and that their continued support depends on the findings of this committee. We urge you, be bold, be the circuit breaker. This is an opportunity for New Zealand First to lead, not follow ACT's libertarian blueprint. If you are truly listening, then let your response reflect the voices of the thousands who oppose this bill, not just the lobbyists who support it. We stand in solidarity with submitters before us, who warns this bill destabilises law, doesn't strengthen it, who exposes its erasure of whakaputanga and te tiriti, who reject it outright for its attack on tikanga Māori, who highlights the twisted logic of equality used as a smokescreen to deny rights to those with objective differences. This bill weaponises responsibility and turns it into a tool to punish kaupapa Māori and working class communities. Where to from here? We turn our eyes to Tamaki Makaurau in the coming by-election, to the local elections, and to every other space where community power must rise. Our Tunaranga Tiratanga does not reside in this house alone. Thank the atua for that. It lives in our whenua, in our whānau, and in the unrelenting vision of a future beyond colonisation. We come here hoping that our opposition is recorded in your report, hoping our truth will matter, but we are not naive. We will continue our resistance in our communities, on our whenua, in our schools, on our streets, and in our minds. Because hopes and dreams are too sacred to be held hostage in this room. We are clear the Regulatory Standards Bill must be withdrawn, not amended. We are not asking for a better version of a bad idea. We are demanding its end. Our recommendations: withdraw the Regulatory Standard Bills entirely, strengthen protections for Māori rights, centre communities over corporations, enhance environmental safeguards, support local governance, commit to genuine consultation. We do not consent to being legislated over in absence. We arrive to recentre what has been ignored. We are embodying a refusal of harm, of erasure, of injustice. We speak because whakapapa obliges us to. Te tiriti is our foundation. Mana motuhake is our compass. This bill does not align with either. I leave you with a saying in our community: the leader is never greater than the people who support it. With honour, with rage, with whakapapa, Pacific Panthers.
Kia ora, we have time for a quick question from Mario Mino Kapakingi.
Tēnā koe, Mr. Chair. E te ao tēnā ro hoki koe mihi atu ana ki a koe tino pono wā kōrero. Just to, one of the previous presenters talked about this bill as merely information, and it's about transparency. You know, and the way I'm saying it is actually how it was put. I mean, your kōrero, pono marika te katoa. What's your sense when this is touted as it's purely information, it's all about transparency, and it makes good law?
I think these words, the rhetoric that's used is to, you know, present that, and there is information within the bill. You know, if the extent of the bill, I'm still working through that comprehension, as many are. But for transparency, it's been said in many submitters and experts, is that the transparency is seen through the eyes of the writers.
Yes.
Okay, and so when you have that information and the context behind it, but you don't present that in detail, and when people are reaching out and asking for that, and then all we receive is modifications of the word transparency, of the word, of the terms information, but we don't actually presented the detail, then that in our puku, in our guts, in anyone's intuition, you know there's something been hidden. And you would speak loudly if this was genuinely as transparent as you want it to be, and you would provide the underlying details and the thinking behind it so that everyone in this country can grasp it, can comprehend it, can work with it, and you would open it up to the public. And so, you know, like I said, in terms of leading the way, you would ensure that the people have the greatest sense of comprehension and confidence than just the writers in that room. So I would disagree with that.
Thank you, Tiao. Appreciate your submission, both written and oral, coming in today.
Kia ora.
Kia ora. We're now going to go to John Canton from Canton Consulting. So this is an organisational submission also of 10 minutes. John, if you can hear me, you feel free to leave a few minutes at the end for some Q&A. Welcome, John. You're just on mute.
Okay.
Thank you. In your hands.
Thank you. Thank you for the opportunity to sit on this side of the table for a change. You may not quite just see the top here. I'm a Warriors fan and have been for many years. So each season I follow the roller coaster of the highs and lows.
It's a pretty apolitical team to support. So
absolutely, I tried to be in this one, Ryan. When I look back at some of the highlights of the old rugby league games, the highlights are full of stiff arm tackles and brawls. When you look at today's product, it's very hard to find a stiff arm head high tackle. And brawls have been replaced by melees. The people with the responsibility for the governance of the sport have taken into account safety and transparency to rewrite rules to improve the product. I use this example as a way of saying that regulation is inherently neither good nor bad, but is certainly needed to make life much better. With that very quick introduction, I just want to highlight 3 themes from my written submission: certainty, accountability, and sustainability. In my written submission, as an aside, I do point out what looks to me to be the contradictory position of promoters and supporters of the bill, that yes, it will completely rewrite and take the culture of New Zealand so that productivity will be enhanced, but at the same time saying we have nothing to be concerned about. Since I wrote that submission, I have engaged online with some supporters of the bill, where the overlap with those who complain about, and there's some overlap with those who complain about judicial activism. By definition, the complaints that they have about those cases is that they would have thought the law was not as the judges said it was. My concern is that that same activism, because I know that there are both imaginative and clever lawyers who will take a claim on behalf of their litigants and clients, and they will actually take these cases to court. How they might do that, beyond my expertise, but there might be an inherent jurisdiction of the courts to allow a claim to progress, or they may be able to entertain a judicial review decision of the Regulatory Standards Board as examples. I've had a quick look at the Bora advice. It's basically a one-liner saying that the Act is not enforceable. It doesn't address any of the concerns that you'll have heard many times already, that the Act does go further than that the bill would go further than that. I think that the committee needs to give us a clear answer. I think read the bill as a slogan and not an answer to the concerns of submitters, that the bill will actually change it. If I make this a little bit concrete, if a government were to say no smoking, I think as taxpayers we would be keen to make sure that there would be no compensation having to be paid as a result of the bill being enacted. I think in the second theme is accountability, and that is said to be one of the aims of the bill, holding the executive to account. By definition, the opposition doesn't have the numbers to do that, because the majority of government MPs, both in the House and on select committees, means that the opportunity to hold ministers to the executive to account is more limited, and perhaps even more so if ministers are not prepared to listen. I think that comment has implications for both standing orders and also for how caucus operates. I use in my submission the Pay Equity Act as a recent example of what seems to me regulation which didn't follow the principles of consultation, regulatory impact statements, or even cost-benefit analysis. From what I've been able to gather, the Treasury analysis of the investment boost policy in the budget, which gave us fiscal offsets, fiscal costs, GDP impacts, was not presented to Parliament for the Pay Equity Act. And if I were sitting here and in front of the select committee, I'd be turning to my left and saying, if this bill was enacted, how would this have made a difference to how you approach that pay equity bill? What questions would you have asked of ministers? Would it have changed your vote? The answer might be that the pay equity bill was good policy, but the regulatory standards bill is about how you get to good policy. If you haven't gone through the process of good policy making, what would you do to hold your hand up and say, this isn't, well, you haven't done the mahi, you need to do the work. If I was in the room, I'd turn to my right. Recent examples are always that much easier to bring to mind, and I'm sure officials sitting in the back room may probably have examples where they would say legislation of previous parliaments didn't meet these standards. I would ask the same questions. Were you able to hold the executive to account? Why didn't you hold the executive to account? Would the Regulatory Standards Act make any difference to how you operated? I asked that same question. And on to my third theme, which is that of sustainability. Some of the select committee may know that my interest is in tax policy and tax. I submitted to the select committee on the tax principles bill. I supported those principles. Didn't like the bill because I thought the way the bill was drafted was too partisan, and I thought the select committee did a good job of the report back. But the answer there was, the point here is that bill did not get the support of the House, didn't get the unanimous support of the select committee, and it was repealed within a month of elections. So the points I want to make here is that the bill will require work. It will require reporting, some of it not due until 2030. What I haven't heard is any concern from, say, the Taxpayers Union that this will end up being wasted money, because the principles that are being applied in this work and this reporting will not be accepted by a future government. So the reports that will be produced will simply be put in the basket. So where I get to, I think I opened my submission with a pessimism that the bill could be amended to actually get that unanimous support. But I think I'm always an optimist, and I do, the Honourable Chris Finlayson in his Yes Minister book said that the real work of Parliament was when Select Committee rolled up their sleeves and produced good policy and good outcomes. And I think that is the challenge for the committee, to actually say, what would this act look like that I could fully support and apply, whether I am on the government benches or on the opposition benches? So I've run on a little bit, but happy to take any questions.
Yeah, thanks, John. We've got one from Dr. Deborah Russell.
Thanks, John. Really good to hear from you and to hear your analysis of this, and I take your points about the tax principles bill. You talk about the regulatory takings and compensation for regulatory takings, but also in that case you suggest there should be a reciprocal thing, that if you benefit from regulation, perhaps you should pay some extra tax, or whatever. Can you just elaborate on that a little?
Okay, so if I use the investment boost policy as an example, that gave further deductions up front. Those who've benefited from that, the question that should be asked is, do the current regulatory tax settings take that into account? So, for example, and I know that you might switch off on my left, if you're giving an investment boost, you're giving a tax saving now. Should that mean that any capital gains, for example, should now be within the net? I use examples of sort of like the land taxes of the 19th century, when from the Honourable Paul Goldsmith's book on the history of taxation, the justification for land tax was the government spent a lot of money building railways and the land value increased, so the land tax was a way of paying for that. So we tend to think the focus of the bill is if your property is being taken away, you should be compensated. That's a very loose summary of the proposition. My proposition is that you should also take into account if your property value is being enhanced, what is the benefit that should that benefit be recognised through a charge in some way? The answer may well be no, but that's the question that should be added.
Thank you,
Thanks,
John.
John.
I appreciate your written submission and personal engagement. Very helpful.
Thank you.
We're now going to move
up wires. Sorry, Ryan.
Up the wires. We're now going to move to Max Harris. This is another. This is a personal submission, so it'll be 5 minutes. Max, I can see you there. Welcome.
Kia ora, Ryan. Kia ora tātou. Yeah, my name is Max Harris. I'm a lawyer and I've worked in economic policy, and I'm also a fan of the Warriors, like the last minute. I'll just recap what I said in my submission, make some points about economic efficiency and good lawmaking, and then wrap up. So I assume you've got my submission. It says why regulation can be important and what regulation is. Regulation includes, for example, requiring the wearing of life jackets, to raise one topic that is before Parliament. It includes how regularly sleeping infants are checked at early childhood centres, to raise something else before Parliament. It includes other aspects of public safety that are in my submission. The other point I make in my submission is that I do think this bill is a wolf in sheep's clothing. I think that even though it's presented in relatively cold terms, that there is a libertarian worldview behind this that is important to understand, and a worldview that I think does not reflect the majority of opinion in New Zealand, and that is deeply antisocial. And I think it will be wrong to elevate that worldview to the level of human rights. I say in the submission that there's not good evidence that New Zealand has a problem with over-regulation. Third, that there's a good case to make that New Zealand is under-regulated, and that in my view, the bill is aimed at making regulation harder. I mentioned the 4 key interventions in the bill and the problems I have with those 4 interventions. I note that poor process has accompanied the bill, and that it should be discarded. I just wanted to make some further points about the coalition agreement between the National Party and the New Zealand First Party, because that agrees to pass a Regulatory Standards Act to ensure regulatory decisions are based on principles of good lawmaking and economic efficiency. And I think that there is a good argument that the bill in its current form is not based on good lawmaking or economic efficiency. So to start with economic efficiency, as the previous submitter said, it's hard to make blanket judgments about regulation beyond particular sectors. And I think one of the problems with the bill is it takes a blanket approach to regulation across the board. But I do think, first of all, that under-regulation can lead to inefficiency, and that we've seen that with the leaky buildings crisis. We've seen that with financial crises where under-regulation has resulted in significant economic and social cost. That's the first point. Second point is I think the bill creates significant uncertainty about the statute book. It essentially puts powers with the Regulatory Standards Board to attach red flags to existing legislation, and I think that produces uncertainty for individuals that want to know what the law is and what the law is likely to be, and I think that's counter to economic efficiency. And thirdly, I think it creates costs for the public service and for public projects that are counter to efficiency. So some public works are important for efficiency that will be discouraged by this bill. And I've seen Treasury advice through Official Information Act requests that also suggests that this bill will create costs of tens of millions, including in the new statutory powers that it introduces. So I think there are 3 reasons why this bill is potentially counter to economic efficiency. It's also counter to good lawmaking because of the inadequate engagement that it's had with advice, including from the Waitangi Tribunal, because it in many ways is redundant, and we already have a regulation review committee, and also because it's been rushed. Finally, what I would say is that I'm very committed to trying to think about constructively, as the previous submitter said, when bills can be improved and when they can be tweaked. But in my view, this bill is beyond repair. I don't think that tweaks or minor changes can address the quite fundamental problems that it has. And for that reason, I'd urge the committee to reject it in its entirety. Happy to answer any questions with my remaining time.
Thank you. We can do a quick one, Dr. Deborah.
Thanks, Max. Really appreciate your submission. I see a real libertarian ideology in this bill as well. We had the Taxpayers Union saying that it wasn't ideological at all. Where do you see the particular, I mean, there's obviously the regulatory stuff, but where else do you see libertarian ideology in this bill, embedded in the bill?
Thanks for the question, Dr. Russell. So just quickly, I think in the regulatory taking clause, we have a clause that goes beyond standard regulatory takings, which already, in my view, reflects a libertarian view, but that applies to expropriation. This goes even further, and it discourages regulation that impairs property rights. So I think that's a key part of the libertarian ideology. I also think the emphasis on property as a right is inconsistent with existing New Zealand law and reflects libertarian priorities. And I think you can see it elsewhere in the bill, and I think it's touched on in my submission.
Thank you. We've met time. Thank you for your submission, Max. Really appreciate that.
Thank you.
We're now going to move to the Department of Public Health, University of Otago, Wellington. We've got Calvin Cochrane and potentially Michael Baker and Dr. Amanda D'Souza joining us.
Kia ora koutou, ko Amanda D'Souza, toko ingoa. I am based at the Department of Public Health in Wellington, where I'm a public health physician and the acting head of department. I'm joined by Calvin Cochrane, who's a research fellow with our Aspire Smoke-Free Aotearoa 2025 research group. Michael Baker will be doing another presentation under the Public Health Communications Centre later this week. So thanks for the opportunity for letting us present today. Our department, our expertise is health, and particularly the drivers of population health. We're particularly interested in the big drivers that drive patterns of health across the country and that drive the differences between groups. Health inequities are the systemic differences between groups that are avoidable, preventable. These are our areas of interest, and we cover lots of different aspects of public health in our department. It's a large department of over 100 people. Our department is unanimously opposed to this bill. We're extremely concerned about the potential harms from this bill in many aspects. Firstly, we think it presents unacceptable risks to public health, the environment, and to Māori Crown relations. We are concerned that it does risk embedding the libertarian values at the expense of the obligations under Te Tiriti of Waitangi, at the expense of public health, and really at the expense of the well-being of our planet and ecosystems in our country. The legal, constitutional and practical reasons for why this bill should be rejected have been well documented, and we believe that they are of such significance that this bill should be rejected. Constitutionally, it risks undermining really critical principles and obligations under international human rights law and under Te Tiriti. We don't believe it's going to address the aims of improving the quality, accountability and transparency of lawmaking. We think it is more likely to do the opposite. There are regulatory failings, and this bill really risks our ability to address those regulatory failings. And so some of the key regulatory failings in public health, these relate to laws to address tobacco and vaping related harm, addressing the harm from junk food, highly processed food and beverages, fossil fuel related harm, alcohol related harm, And these public health issues cause enormous costs to the country and an enormous burden on the health system and on individual lives and whānau lives. I'd also like to draw your attention to the regulatory failings in relation to Te Tiriti o Waitangi. The Waitangi Tribunal outlines in many aspects of public life how our laws need to be strengthened from a Te Tiriti perspective. And this bill potentially really undermines that by completely neglecting to list Te Tiriti as one of the primary principles and values. Another important regulatory failing that I'd like to highlight is the Royal Commission of Abuse and Care, and really the systemic failings in a whole lot of regulatory standards over decades that have caused billions of dollars of harm and enormous flow-on effects to people's health, education, social outcomes, justice outcomes. We've got a whole lot of recommendations from the Royal Commission. Many of them are regulatory in nature, and these are the sorts of failings that need to be prioritised to improve the situation in Aotearoa. So just to really highlight our recommendations, we really recommend withdrawing this bill and stop it from proceeding. Strengthen and embed in domestic law legal protections for Te Tiriti, all human rights treaties, and the environment and public health. We really would not like to see any bill that potentially risks entrenching power and privilege of wealthy private individuals and commercial interests at the expense of our Indigenous people, children, young people, people from marginalised groups, and our public health and environment. Our third recommendation relates to improving the quality, transparency and accountability of lawmaking by regulating lobbying by commercial interests. And we've outlined that in one of our Public Health Communications Centre expert briefings. We would like to see stricter rules on political donations, greater transparency about conflict of interest, closing the revolving door between lobbying and government, and introducing a lobbying register and a code of practice. So those are our big picture, broad brush of our submission. I'm going to hand over to Calvin.
Thank you, Amanda. Yeah, so this bill may mean that our system of government is likely to end up in a very uncertain and unstable place, one where the balance of power disproportionately shifts to favouring the prerogative of corporate interests who may ultimately decide the fate of our laws. The uncertain nature of how this bill will be applied in practice may mean that life-saving regulations and laws that previous governments have passed, including anti-smoking and alcohol laws, may never have been allowed if this bill was in place. And the future of those laws and regulations is at grave risk of being unpicked because they don't conform to the principles of this bill. And the crucial point of public health laws is they often need to evolve to keep up with industry adaptation and countermeasures. And the Smoke Free Environments Act of 1990 is 35 years old, and in that history has been amended several times as more measures were needed to save lives and to, evolve with the changing and emerging evidence of the addictiveness of nicotine and deadly consequences of tobacco. So legislation to protect and improve health and well-being often does challenge the rights of some companies, and especially those companies who choose to prey on and addict young people to nicotine products, for example. So the government could potentially be in quite a dangerous position with this bill, with corporations having sort of a lot more power to challenge existing laws and regulations. So companies shouldn't have the right in the pursuit of profit to harm others, especially those most vulnerable and in need of their government protecting them. Yet this bill may hamper the ability of governments to make laws or regulations to do exactly that. So we recommend that this bill is withdrawn. Thank you.
Thank you for your submission. We have got a little bit of time, but there doesn't appear to be any questions. So we'll thank you for both your written and oral submissions.
Kia ora.
Kia ora. Members, we're now going to hear from Michael Smythe in a personal capacity. Welcome, Michael. We've got you for 5 minutes, but of course,
thank you.
you're welcome to allow a minute or two at the end for questions.
Good. Michael Smythe, and I'm presenting an improved version of what I wrote. My written submission was something of a sketch. This is more developed. So I'm a designer. As an industrial designer, I'm all for continuous improvement of the way we manufacture legislation and regulation. The Regulatory Standards Bill aims to, quote, improve the quality of regulation in New Zealand by introducing principles for good lawmaking. So I will evaluate it through a design thinking lens. Design thinking is best described with the Venn diagram that integrates feasibility, viability, desirability, and sustainability. Applied to good lawmaking, the 4 circles would integrate fiscal, social, cultural, and environmental responsibility. Any overarching review of regulations should consider all these responsibilities, but the bill only seeks to minimise unnecessary burdens on individuals and businesses. So it falls well short of creating a framework for transparently evaluating proposed regulations. If the purpose of the bill is to advise in order to improve the quality of regulation, evaluation process should consider the fiscal, social, cultural and environmental effects. Good lawmaking should aim for synergy, an integrated outcome that is more than the sum of its parts, a symbiosis in which each element aligns with and reinforces the other. Not a win-lose, the way to win is to make the other side lose approach, which we're far too addicted to. This comprehensive responsibility is what we taxpayers pay our Parliament to undertake. It's capable of continuous improvement, but the Regulatory Standards Bill does the opposite. It limits the evaluation of lawmaking to the needs of individuals and businesses and excludes all other interests. Aotearoa New Zealand is better than that. Along with individual and collective enterprise, our environment, our Indigenous culture, and our social structure are core drivers of our economic prosperity. Integrating them well will improve our economic efficiency. A government that passes the Regulatory Standards Bill will undermine its core responsibilities and thus declare itself unfit to do the job. Thank you.
Thank you, sir. That was very succinct. Any questions from any members? I've got one from Dr. Deborah Russell.
Just to say thank you, Michael, for putting that in and for bringing a design lens to it. It's really helpful.
Thank you. Thank you for that. Thank you. We're now going to move to the New Zealand Council of Trade Unions. We've got Richard.
Yes. Can you hear me, Chair?
Yes, we can. Welcome. We've got you for 10 minutes. Feel free to leave some time for questions at the end.
Thank you, Chair. I'm the President of the Council of Trade Unions, Richard Wagstaff, and this is Jack Foster from our policy team. I want to just start by signalling, obviously, we're joining the chorus of opposition to this proposed legislation. And we note the widespread opposition that there's been in the pre-legislative consultation phase. 88% of people opposed the bill and something like 1% or less than 1% supported it. In addition, the Ministry for Regulation has advised against it. The Waitangi Tribunal has alerted the government it has breached several Te Treaty principles in its development, and the Legislation and Advisory Committee has advised strongly against it. So in that context, from our point of view, it doesn't make any sense for the government to keep pushing this bill any further. This is the policy of a minor coalition party that has no popular mandate, and the tail should stop wagging the dog. So really enough money and time and resources has been wasted on another pet project of the ACT Party, and we think that the senior coalition party, the National Party, should put their foot down and stop this bill in its tracks. I'll hand over to Jack now to go through some details.
Thanks, Richard, and thank you, Chair.
So yeah, I'll just speak briefly to a couple of points raised in our written submission, which covers these points more substantively. So first of all, the Council of Trade Unions does not in any way object to improving the quality of legislation. So we think that's a valid and desirable objective. But the regulatory standards bill that's before the committee will not achieve that objective. So the core of the problem for us, and as has been raised by many other submitters, is that the principles of responsible regulation set out in Clause 8 are selective and ideological. So although the sponsoring minister has attempted to dress them up as neutral standards of good regulatory practice, they quite plainly reflect and seek to embed in lawmaking peculiar and marginal libertarian beliefs about the supremacy of individualism and private property rights. And there are many other far more widely accepted principles that are inexplicably absent from the bill, not least whether legislation is consistent with Te Tiriti o Waitangi, with other existing legislation and international treaties, whether it is evidence-based, whether it is enforceable, and whether it is equitable and sustainable. We know that no logical case has been made by the sponsoring minister as to why the 6 sets of principles outlined in Clause 8 should be treated as supreme. And more fundamentally, we believe that some of these principles are simply out of step with the values that most New Zealanders hold and therefore have no place in our constitutional settings. So this is perhaps most evident in the liberties principle and the taking of properties principle, which we both cover in our written submission. I'll speak briefly to the latter of these. So it's well understood that in the practice of political economy and in moral philosophy, that the unfettered use of private property can have negative impacts, not just for individuals, but for society at large. So it's therefore well understood in New Zealand and internationally that government must be able to regulate private property in line with the public interest. The taking of property principle tries to restrict government's ability to do this by requiring that compensation be paid to individuals or businesses in cases where a regulation impairs the use of their property. Now, this would potentially cut across a huge range of regulation. So, for example, it could impact labour standards, such as health and safety standards that ban the use of toxic products, necessary public health restrictions, such as the successful use of lockdowns during the early phase of the COVID pandemic, which restricted the ability of businesses to operate in order to protect the unvaccinated population. It would also cut across environmental regulations, such as pollution controls and waste disposal rules that protect our natural resources. And it would cut across economic protections, such as the government's recent actions to limit farm to forestry conversions. This would be considered an impairment of property under the RSB, but it's necessary to protect New Zealand's food security, our ability to earn foreign exchange, and the viability of rural communities. So if adhered to, the problem is that the requirement that fair compensation be paid to the owner for any impairment of their property would make these kinds of policies simply unaffordable for government. So they'd be forced into a position of not regulating in the public interest or breaching the principles of responsible regulation. We'd also like to draw the committee's attention to the inconsistency of this bill with one of its own principles of responsible regulation, namely the principle of good lawmaking, which holds that legislation should, quote, be expected to produce benefits that exceed the costs of legislation to the public or persons. Now, according to the Ministry for Regulations analysis, which is the best analysis we have of the potential impacts of this bill, the annual cost of compliance the bill will create would be over 20 million per year, and that's a conservative estimate. Against these very substantial costs, there is no analysis that indicates the bill will improve regulatory quality. The ministry simply notes that the bill is, quote, expected to result in greater transparency of whether legislation meets the specific standards expressed as principles of responsible regulation. But because these principles are so selective, this is not the same thing as improving the quality of legislation. And indeed, the ministry goes on to note that, quote, given the selective nature of the principles and the fact that they do not include many aspects of regulatory quality, it is difficult to assess the overall impact. So in other words, the bill will impose substantial costs on the Crown in terms of compliance with the bill, but there is no evidence to suggest it will deliver tangible benefits. And indeed, we're concerned that the bill will have the exact opposite effect. This is because ministers, agencies, and the Regulatory Standards Board will be compelled to assess legislation only against these flawed and selective principles of Clause 8. And this means there will be significant holes in what is set to become the central standard by which legislation is assessed in New Zealand. So I'll close off my remarks by reiterating what the President of the Council of Trade Unions said at the beginning. In the face of such clear and overwhelming opposition to this bill, it would be highly irresponsible for the government to take this legislation any further. So we reiterate our own opposition to the bill and urge the committee to recommend its termination. Thanks very much for your time, and happy to take any questions.
Thanks, Jack, and thanks, Richard. Are there any questions from members? Very good. Well, thank you both for your submission today.
Yeah, kia ora.
We're now going to move to Te Tura Kaupapa Māori o ngā mokopuna. I'm not sure who's presenting. Rawari Wright. Oh, they're in the room in Wellington. Tēnā korua, can you hear me down there? Liam, can you give us some feedback?
Yes, it seems to be working okay.
Oh, great. Welcome. We've got you for 10 minutes, but please feel free to leave some questions at the end if you would like.
Yep, we'll try and keep it brief so that there is time for questions. Thank you for this opportunity to add an oral submission to our written submission, which we assume will be taken as read. To reiterate, Te Tura Copa Māori o ngā mokopuna opposes the Regulatory Standards Bill in its entirety and submits it should be totally disregarded and dispatched to the delete file. Notwithstanding the enormous negative potential of this bill on all things Māori, programs, legislation and regulations, by way of example, we ask this committee to consider how we see this bill potentially impacting our part of the education sector, being Kura Copa Māori Te Aho Matua. There have only been 4 pieces of legislation which have provided for the eventuality of Kura Copa Māori Aho Matua. The first was the 1987 Māori Language Act, which provided a pathway for total immersion Māori language provision in the education system. The second was the 1988 Education Amendment Act, which provided for the establishment of Kura Copa Māori. The third was the 1999 Education Aho Matua Amendment Act, which provided for Te Aho Matua as the defining aspect of Kura Copa Māori Aho Matua and recognition of Te Rūnanga Kura Copa Māori as the legislative kaitiaki of Te Aho Matua and the whole Kura Copa Māori movement. The fourth was the more recent Education and Training Act, which reinforces the two previous acts in the place of value of Kura Copa Māori as a bona fide education option in Aotearoa, New Zealand. We consider it important that this committee, in fact the whole government and country, understands the history of Māori language education provision in this country. So here is the briefest of backgrounds. 1769, we were discovered. Woo! 150,000 Māori, 100% of whom spoke Māori. We educated our tamariki from a Māori worldview in harmony with the environment. It reinforced whakapapa genealogical ties to the environment and the universe, and the notions of kaitiakitanga, guardianship, and the conservation of limited resources. A system that had been in place for thousands of years in Hawaii, the ancestral home of Māori, and for at least 500 years in Aotearoa. But just 47 years after 1769, 1816, the first school established by missionaries. Te reo Māori was the language of instruction, Christian ethic was the curriculum, and that dislocated and disemboweled Te Ao Māori and its value systems. Remember, the first 31 years of formal education in this country was in Māori, notwithstanding the previous 500 years. 1847, the Education Ordinance was the beginning of the education system as we know it. But it took another 140 years, 1987, we loop back to there, before it was once again legal to teach in Māori in the education system in this country. So the education system is now 209 years old. We, Tura Copa Māori, are just 40 years old. And yet we lead the way in many innovations in the education sector, and our tamariki outperform all other education options in NCEA. Ask the Minister of Education, she knows. This bill is destructive. And as the CTU and others have said, it is dismissive of Māori aspiration for tino rangatiratanga, mana motuhake is guaranteed in Te Tiriti o Waitangi. It makes no mentions of state obligations under Te Tiriti o Waitangi towards Māori, no acknowledgement of Māori Indigenous rights, and gives no considerations of the notions of collective ownership. Instead, it focuses on individual rights, the accumulation of wealth by individuals and companies, and the exploitation of resources, which would inevitably lead to continued environmental degradation. It promotes only one worldview of the right kind of legislation that is good for the country, but that is only from a white monocultural worldview. By definition, therefore, this bill is racist in design and should never claim to be the basis for responsible lawmaking in Aotearoa. In its 2010 preliminary report on the state and the well-being of Te Reo Māori, the Māori language, the Waitangi Tribunal said, while the state of the language was not well, were it not for the efforts of Kohanga Reo and Tura Copa Māori movements, the state of Te Reo Māori would have been far more dire. It went on to say, both movements were critical to the revival, retention and development of Te Reo Māori, and therefore the promotion of Māori customs, traditions, mātauranga and ethos. Were it to proceed, and given it would provide for retrospective application, this bill could be used to undo all of those efforts, to remove all of those pieces of legislation and offer no state responsibility for the protection and development of Tura Copa Māori, of Te Reo Māori, and therefore taonga Māori as guaranteed in Te Tiriti o Waitangi, not the least of which are tamariki. This bill must not proceed. So that's us, Mr. Chairman. Tāpiri.
Thank you.
Any questions? Happy to take them.
There doesn't appear to be any questions, so thank you for your submission. Oh, we've got one from Hannah, might be.
Tēnā koe e te komiti whakahaere. Tēnā rā kōrua mō te taimā e tēnei rangi ki te kōrero ki tēnei o ngā pire. Ko tahi noi ho taku pātai. Ki o whakaro, heha e tihi o ngā pēhitanga nui ka whai ki ngā whakareanga ngā rangatahi, ngā kura kaipapa Māori, me nā ka pāhi tēnei ture, me nā ka pāhi tēnei pire.
Ko te mataku nui, ka whakakorengia te āheingo te whakatū I nei tū mō kura. Ki te pēra, ka ahatia ngā kōhanga reo, ka kore pēr ngā kōhanga reo, ka kore pēr ngā kura kaupa Māori aho matu, ka kore pēr ngā kura iwi. And so a whole education option which contributes to the well-being, the revitalisation, the retention and the ongoing development of Te Reo Māori, of mātauranga Māori, of everything, will be denied future generations, as it was denied the generations before you, Hana, before Te Wehi. I'd cry at the thought of what could be lost, what could be denied future generations of tamariki mokopuna Māori. Tēnā koe.
Kia ora, tēnā koe.
Kia ora, thank you, gentlemen, for your submission and coming in to Wellington this morning.
Tēnā koutou.
We're now going to move to Paul Rishworth and Tim Stevens of the New Zealand Law Society. Tim, are you kicking us off?
I am. Tēnā koutou. I'm Tim Stevens, and Paul Rishworth, I believe, is also online.
Yes, he is.
And we're here for the New Zealand Law Society. So thanks for having us. You will have read our submission, I think, so we don't propose to go through it. In the time available, we just wanted to focus on a couple of things and then answer any questions that you might have. I think the first thing we want to say is that we should actually all be able to agree that New Zealand could do better with its arrangements for legislative design. At the moment, the guidance and requirements in this area are distributed across different agencies. They're relatively informal and they have limited accountability mechanisms. But the second thing we want to say is that the bill is not an effective response to dealing with these issues. And I think the reason for that is that the main mechanism in the bill is a transparency mechanism. So you have a consistency accountability statement from the chief executive, from the responsible agency, and then a statement from the responsible minister in a bill's explanatory note that briefly explains the government's reasons for any inconsistency with the principles of responsible regulation that are identified in the consistency accountability statement. And so the key point, I think, is that transparency mechanisms only work if transparency engenders a sense of obligation or shame, or just potential downsides for the person responsible for the matters being highlighted. And it seems to us that there's just no real prospect that the transparency mechanism in the bill will have that kind of effect, that kind of motivating effect for the minister responsible for the bill. I mean, we already know the principles of responsible regulation in the bill. In general terms, we might quibble with how some of them are worded, but they're well established. And we can see that ministers, both in this government and in past governments, can discount these principles on the basis of a political calculation that any repercussions or consequences won't be a problem or will just be worth it. And for an example of that, it's hard to go past this bill itself. It's striking that a bill purporting to promote good lawmaking and high quality legislation should so conspicuously fail to meet its own standards on those fronts. So there is an issue about whether the key issue that we want to highlight is that there is a question about the effectiveness of this bill as a response to dealing with issues about legislative design and good lawmaking. I think the third thing we wanted to say is a point about durability. If we're genuine about improving legislative design, promoting good lawmaking, then the response to it needs to attract a broad consensus. This area shouldn't be a political football. And you will all know that the bill puts forward abstract aspirations for good legislation and includes principles about liberties and property, but omits standard matters that you would expect to see in the same company, such as privacy, environmental concerns, New Zealand's international obligations, and of course the Treaty of Waitangi. And in our view, those are obvious gaps that damage the credibility of the bill. And it means that the bill is highly unlikely to be durable across successive governments, and so highly unlikely to achieve its stated aim of improving the quality of legislation. So with those points, those were the points that we wanted to highlight, and Paul and I welcome any questions that people may have.
Thank you. We've got a question from Donna Williams.
Kia ora to you both. Interested in a perspective from both of you on what better arrangements in New Zealand for legislative design look like, particularly your point around accountability and a lack of ministerial accountability or mechanisms for formally checking that. I'm also asking I am the chair of the Regulations Review Committee, a bipartisan committee set up by the Honourable Jeffrey Palmer with bipartisan support from the National Party to consider the way that not only delegated authority, but law generally as it applies to secondary decision makers works, and to provide Parliament with a mechanism to do that in a cross-partisan way. How do you see those powers needing to evolve over time? How should the legislative design expert committee be operating as it is now? Do we have enough responsibility built into the system, or do we need new powers?
Well, I'll start by saying that currently, the various mechanisms are distributed across different agencies, and they're relatively informal. And so for example, have the cabinet impact analysis requirements are in one place. You've got LDAC's legislative guide in another place, and so the first step might be to house all of the precepts for good lawmaking in one place, and that might be the current Ministry for Regulation, which is assuming that role anyway, and so that could be kind of agnostic about the place as such, but much better if it were in one place. And then the second point is, in terms of the committee that you're on, that's the type of example where you could improve the political culture by having more focus on legislative design precepts, both for legislation itself and secondary legislation such as regulations and so on. Don't know do you want to add to that, Paul?
I think it's important to see that a number of the proposed standards in this bill are very much about the process by which law is made. And as Tim says, there are codes and guidelines that speak to that. If assembling those into one place so they're readily accessible, that can easily be achieved, so that sort of takes care of that. It's when it comes to the substance of the law, which some but not all of these standards speak to. Just really, it's the taking of property and the liberties part that speaks to the substance of law. I see that very differently. I think we're there in the realm that has, at all times in our tradition, been a matter of politics. That, going right back to the origins of Parliament, it's the people of the realm being assembled to debate and weigh up and decide, do we need to do this? And if we do that, then there's that harm caused. But to make those judgments. And I think that needs to be sort of nurtured and valued in our system, because that's what the political system is all about. And we rely on good people to be there with good judgment. And I guess that's the reason why I'm sort of not attracted to taking out those very fundamental values and putting them in an ordinary law that says such grand things, and then consigning that to 5 people appointed by the Minister for Regulation to pronounce upon whether something has been achieved. I mean, if you're serious about putting substantive constraints on legislation that have the power and history and the meaning of the ones in these standards, then you're looking at bills of rights and the idea that the legislative power is constrained, and then you're looking at that going to the highest court in the land. So I guess that's my concern, that there's things mixed together in these standards, the high values and principles. Then there's the things that are just the law anyway, like the taxes and fees. And then there are things about good process, like making sure you're doing something that isn't already in the law. It's a strange amalgam of things.
All right, well, thank you for that, Paul. And Tim, appreciate your submission today.
Thank you.
Thank you very much for having us.
We're now going to move to the Latin Americans supporting Tino Rangatiratanga. And I believe we've got, is it Gove?
Gove.
Gove. Welcome. We've got you for 10 minutes, but of course, it's a guide, not a destination, and you're welcome to leave room for questions.
Awesome. Tēnā koutou te committee. Ko Gove Graveness Tokingoa, and I speak today on behalf of Latin Americans supporting Tino Rangatiratanga. We are a collective of migrants from across Latin America who have come together in Aotearoa to uphold the values and principles of the Tiriti o Waitangi. And I'm going to read the expanded document that we submitted. But before that, I wanted to put forward our position and why we are here, and I wanted to introduce myself. Where I come from and where we stand for. So my name, as I said, my name is Garry Moore. I come from the west of Mexico. I am a migrant. I came to this whenua, which now I call home, 14 years ago. I am queer, I am disabled, I am an environmental scientist and a linguist studying and working in Tamaki, Makaurau, Auckland. I carry colonization in my veins as I do not know to whom the line I grew up on belonged to, but we foolishly look to Europe as an example to follow. I have been disconnected from my indigenous roots by generations of ideological imposition. I am humble to call this place home. Matereo e hao e whakakaha, matereo hao e noho hei tangata tauiwi. He uri mestizo, he uri take kua hono ki te mana, o te whenua o konei, he hohonga tapu. So we are presenting before this select committee because we feel a deep responsibility to speak out against the Regulatory Standards Bill. As people from colonized nations, we recognize the patterns of harm that this bill represents. We see its ideological roots in the same liberalist frameworks that have historically undermined indigenous sovereignty, dismantled social protections, and deepened inequality, both in our homelands and here in Aotearoa. So we would like to first support our strong opposition to this bill by affirming our unwavering support for the Te Tiriti o Waitangi as a living covenant governing the relationship between Tangata Whenua and all others who reside here to this day. As Tau Iwi, we understand that our right to be here is conditional upon our respect for and upholding of the Tiriti and our active support for Māori Tino Rangatiratanga. This bill, in both process and substance, we believe is a direct breach of that covenant. Thus, even though Māori sovereignty is guaranteed under the Tiriti, the Regulatory Standards Bill was introduced without meaningful consultation with Māori. This omission is not just a procedural oversight, it is a foundational failure. We believe the rushed timeline, the lack of transparency, and the dismissive attitude towards public concern, especially following what we saw as the widespread opposition of the Treaty Principles Bill, have further eroded trust in Crown's commitment to honoring the Tiriti. This is not how legislative change should be made in a democratic society, let alone in a nation founded on agreements of partnership, respect between people. Māori have always embodied a vision grounded in collective responsibility, intergenerational well-being, and deep relationality with the land and each other. Concepts such as tikanga, manakitanga, kaitiakitanga, and matauranga Māori offer a rich framework of governance, far more holistic and sustainable than the narrow individualistic lens of this bill. This bill makes no space for these and imposes a rigid Western legal framework that silences Indigenous and other kinds of knowledge and undermines Māori leadership. This is not only a breach of the Tiriti, but it's also a loss for everyone who calls Aotearoa home. The bill's proposed text prioritizes individual rights and economic freedoms over collective well-being, over equity, and over justice. These are not neutral values. They reflect a specific ideological agenda that has historically harmed marginalized communities. For example, for us in Latin America, from all the way north to south, Mexico to Chile, we have lived through the consequences of similar policies. Deregulation, privatization, and the erosion of public institutions in the name of efficiency and freedom. These policies have widened inequality, weakened Indigenous rights, and left millions without access to basic services across our home countries. We see the same risks happening here. The proposed Regulatory Standards Board, which constitutes an unelected body with sweeping powers, would centralize decision-making in the hands of a few, with little accountability to the communities most affected by those decisions. This is not democratic, and this is not justice. As Latin Americans, we carry with us the scars of colonization. We know what it means to have languages suppressed, land stolen, cultures commodified, and people marginalized in their own territories. We also know what it means to resist. That is why we stand in solidarity with Tangata Whenua in opposing this bill. We recognize the parallels between our histories and support the ongoing struggle for Tino Rangatiratanga in Aotearoa. We know that when Indigenous rights are undermined, all marginalized communities suffer. This bill is not just a Māori issue, it is a human rights issue, it is a migrant justice issue, it is an environmental issue, and it is our issue too. We urge this committee then to reject the regulatory standards bill in its entirety. It is not fit for purpose, it is not grounded in the values of the Tiriti o Waitangi, and it does not reflect the aspirations of the diverse communities who call this land home. Instead, we call on you to uphold the Tiriti o Waitangi as a supreme foundational document of a multicultural Aotearoa New Zealand, to ensure Māori leadership in any future regulatory or legislative reform, to reject libertarian frameworks that prioritize individual gain over collective well-being, to invest in equity, not just equality, and recognize the historical ongoing impacts of colonization on Māori and other marginalized communities. And finally, listen to the voice of tangata whenua who have been clear, consistent, and courageous in their opposition to this bill. We are here not just to oppose a bill, but to affirm a vision of Aotearoa where the Tiriti is honored, where Indigenous leadership is respected, and where all communities, regardless of origin, can thrive in dignity and solidarity. To close, a dear friend of mine gifted me this whakatauki, tuia irunga, tua iraro, tuia te muka here tangata o ko tiu nei ia tātou. Unite above, unite below, unite the fibers, bind our people together. No te whenua taurikura o Mexico ki konei ki Aotearoa, te whenua takerake o te Māori, ka tū ko tahi ai tātou. Honremos el tratado, toi te tiriti, thank you.
Thank you, Gove, for your
questions.
submission.
Oh, thank you.
I don't believe we've got any questions for you, so thank you for that.
Thank you. Kia ora.
Kia ora. We're now going to move to Lawyers for Climate Action New Zealand Incorporated.
Kia ora, tēnā koutou, and thank you so much for giving us the opportunity to speak on this really important bill. My name is Jessica Pallaret and I'm joined by Molly McDougall, and we're from Lawyers for Climate Action New Zealand. Lawyers for Climate Action is an incorporated society with over 370 members from across Aotearoa. We're lawyers who want to see effective action on climate change. Understand that over this next week, you are hearing from many senior leaders across civil society, academia, the legal community about the myriad issues with this bill, from a te tiriti perspective, a constitutional perspective, a procedural perspective. Our next focus, or our focus for the next 10 minutes, will be to discuss the significant issues that this bill presents from a climate perspective. And this is the key takeaway for you. This last week, we have seen devastating storms rip through the Nelson Tasman region. And the evidence is clear that we will only see more extreme weather events like this, that we're going to increase in severity and frequency because of climate change. What this means is that we need our laws and our legal frameworks to actively enable the transition to a low emissions economy. This bill would act as a blocker. It's a bill that sets out to improve the quality and transparency of lawmaking in New Zealand, but it's fundamentally misconceived. We're concerned that it will make it harder, more expensive, and ultimately slower to pass the effective climate change laws and regulations that we need. We're going to split our submission really into two parts. I'm going to start talking about issues with the principles, and then Molly's going to take you through what this bill could actually mean when it comes to time for the Climate Change Response Act to be reviewed by the Ministry for the Environment, to really demonstrate how flawed and misconceived the bill is and why it really won't do anything constructive for Aotearoa. So starting with the principles, these are really at the heart of the bill, but as you will have heard from many people, the bill sets out principles that are ideological, narrow and selective, and ultimately are a completely inadequate benchmark against which to assess legislation, particularly as it relates to climate change. This is because they exclude many important principles relevant to good lawmaking. Te tiriti, the precautionary principle, consistency with New Zealand Bill of Rights Act, the importance of evidence-based lawmaking. But they also embed norms of rules and regulation making that are inconsistent with our international environmental obligations. They'll create regulatory uncertainty and, importantly, will have a chilling effect on pro-climate and environmental laws, as the principles assume the prioritisation of individual liberties and property rights over collective interests like the right to a safe and healthy environment. The principles mean that we'll view laws in terms of their restrictions on private property rights rather than their wider benefits, such as the inherent value of increased biodiversity or emissions reductions. Molly's now going to talk through the Climate Change Response Act to demonstrate just how ineffective the bill would be.
To illustrate the practical realities that this bill would create, I'll use the Climate Change Response Act as an example, to show how unworkable and unhelpful the highly selective principles are in practice, entangling officials in a time and resource-intensive exercise. The Climate Change Response Act, amended with near unanimous support by the Zero Carbon Act, is our critical climate legal tool, enshrining in law the essential 1.5 degrees Celsius temperature goal. Under this bill, the Ministry for the Environment would be required to review the Act and provide a consistency accountability statement. The Ministry of Climate Change would then be required to justify any inconsistency and outline any proposed actions, if any, to remedy the inconsistencies. In the interest of time, let's look at how two of these principles might be applied to the Climate Change Response Act. The principle of individual liberties in Clause 8b is fundamentally at odds with the purpose and function of the Climate Change Response Act. Under this principle, the only grounds for diminishing one person's liberty is to protect the liberty, freedom, or rights of another person. But that's not how climate law works. Climate law, by necessity, constrains individual liberties to protect the public, including both present and future generations and the global community, safeguarding our collective interest in having a livable future. This principle also diverges from the broader public harm principle that underpins climate law, where we accept that some constraints on individuals are justified and necessary to protect the common good. The takings principle in Clause 8c creates an expectation that the government ought to provide compensation whenever regulation impairs private property rights. The problem is that this occurs in climate and environmental law and regulation all the time because it has to. As a recent example, take the government's proposed restrictions on farm to forest conversions under the Climate Change Response Act. This would impair the right of property owners to convert productive land into forestry, potentially reducing expected land use returns for some landowners. This bill could create a presumption of compensation for this impairment, disincentivizing an amendment that is seeking to address a serious collective concern in rural communities. This raises the question, what would be the benefit of this exercise to the country? Officials and the minister will spend a significant amount of time justifying complex, evidence-based legislation with near unanimous support against a set of principles which are misguided and selective. It won't tell us whether the Act is effective, it won't help us improve the Act, and it won't advance climate outcomes.
To the extent that there are issues with the cost and design of legislation and regulation in New Zealand, this bill isn't the way to fix them. We won't be left at the end of that exercise with any idea for how the Climate Change Response Act could work more effectively or whether it's achieving its purposes. We could actually be left in a situation where the Climate Change Response Act comes up pretty badly against the so-called principles of good regulation in a way which could be really harmful to our climate response. This bill also gives the minister an incredible amount of power, allowing him to choose who sits on the board, publish guidance on how the principles are to be applied, and direct the board on which legislation to review. That's really concerning. It adds red tape and cost for no clear benefit and attempts to create a benchmark for good law and good regulation that's fundamentally at odds with what's required for good climate and good environmental law. And on that basis, we urge the committee to not proceed with the bill, or at least significantly amend it from what we've currently got. We've left a little bit of time for questions, so very happy to take any in case the committee has them.
Thank you, Jess and Molly. Very solid presentation. There doesn't appear to be any questions though. So we'll thank you for your time this afternoon and wish you all the best.
Thank you very much. Ka kite.
Ka kite anō. Liam, have we got, yep, we've got Dr. Mel Barton has arrived from the Tree Council. Dr. Mel's, thank you for joining us. We've got you for 10 minutes, but of course you can finish early and if you want us to ask any questions. Welcome.
Thank you. Tēnā koutou, tēnā koutou, tēnā koutou katoa. Ko Mel's Barton aho, no England aho, no Te Tarangi ki Kāinga, ko Ho Hill and toko maunga, ko River Trent toko awa, taku marama, Te Wainui Tirawa Toku. This submission is made by the Tree Council, an independent voluntary organisation. We're a non-profit incorporated charitable society which has been serving the Auckland community since 1986 in the protection of trees and acting as advocates for the significant benefits and services that our trees and green spaces provide. We've made submissions on many, many pieces of legislation over the years. Our board comprises highly qualified and experienced professionals, so the submissions that we make are well informed and based on years of experience dealing with the particular issues covered by that legislation. I personally worked for the Environment Agency in Wales for 9 years, where my job involved translating EU directives and UK legislation into National Environment Agency policy. I know good law and bad law when I see it, and this bill is bad law. We object to the Minister's public statements that the opposition to this bill is based on misinformation from people who don't understand it. That is patronising and untrue. We note that its opponents include lawyers, ex-prime ministers, and numerous NGOs who have been heavily involved in the development and scrutiny of legislation of all types for decades. The Treasury did not recommend adopting this bill. We submit that these people have far more relevant experience than the Minister, and that their views and submissions should be given considerable weight by this select committee. The Tree Council opposes the proposed regulatory standards bill in its entirety. It prioritises big business over people and the natural environment. Instead, we need regulations that protect New Zealand's resources, our people, our natural environment, and future generations. Regulation needs to be based on evidence. Its development must be transparent and strategic, and its effects must be proportionate and fair. Obviously, efficiency in regulatory processes is important, but of far more importance are the outcomes for the good of the country and its people. We therefore oppose the bill's focus on individualistic, corporate and property rights and liberties over the public good and environmental protections. This bill is anti-democratic. It prioritises the interests of corporations and the wealthy, taking power away from communities and Parliament. It shifts power from Parliament, whose role it is to balance different interests, and whose MPs are directly accountable to the people, to the executive, centering power in the Ministry for Regulation, and to the non-elected Regulatory Standards Board. This bill is unconstitutional. Any bill must include the New Zealand Bill of Rights as a central principle. This bill does not do this. This bill is fundamentally inconsistent with the Treaty of Waitangi, our founding document. The treaty relationship is long-standing and fundamental to the democracy of our country, and based on good faith between the parties. This bill has not been consulted upon with Māori. It is therefore a unilateral attack on treaty principles by only one party. It will further marginalise Māori rights and values, and it ignores the role of regulation in protecting shared resources that benefit all of us. Under this bill, consultation on future legislation will only occur with those deemed directly and materially affected by the legislation by the relevant agencies. So the public, advocacy groups like ours, and other parties will potentially be shut out of consultations on future legislation or changes to existing legislation. This will lead to bad law, with only a narrow viewpoint being considered and public scrutiny avoided. The Tree Council regularly makes submissions on issues that affect our natural environment. This includes legislation, council plans, and individual consent applications. We are heavily invested in protecting the quality of life for the residents of our cities and the quality of the natural environment that we live in. This bill could prevent us from doing this or open us up to financial penalties from companies whose activities we oppose. An overriding principle of good lawmaking is that all parties potentially affected by the regulation should be able to contribute to the development of that regulation. This includes individuals, groups like ours, experts, and companies. No one should be cut out of this process because the government of the day decides that they will not be substantially affected. This is wide open to abuse and bias and is anti-democratic. This bill undermines the collective interest in favour of corporate interests and private property rights. It undermines environmental protection in favour of corporate interests and private property rights. It undermines the Bill of Rights and explicitly excludes recognition of the Treaty of Waitangi in favour of corporate interests and private property rights. This is not right. Similar attempts to introduce a regulatory standards bill have been rejected by previous governments 3 times, and many aspects of this bill, especially the principles, are largely similar to previous bills. This attempt should also be rejected. The principles are flawed, and they're focused on private property rights, costs and benefits, the rights of individuals and corporations, not on the public good, collective interests, or a healthy and thriving environment. Things that are actually important to every New Zealander. The principles are based on narrow political ideology, and they contradict our existing regulatory systems that protect and enhance those collective interests. This bill would constrain governments from acting in ways that conflict with those principles, even where the public good would justify it. It would lock in these constraints for future governments, requiring corporate compensation to make changes. It is a shortcut to deregulation for potentially all of our laws. We oppose the bill's focus on individualistic, corporate and property rights and liberties over the public good and environmental protections. The focus on these individual rights minimises the extent to which the precautionary principle can be applied in regulation. This will directly affect environmental protection and will not protect the interests of future generations. The principles will require compensation to be paid where private property rights are impaired. We object to this takings clause. There is a huge financial risk to us all and to the government in this clause. This bill could make ratepayers, taxpayers, environmental groups, iwi and individuals pay billions to corporations if regulations affect their property rights. It is a direct attack on collective benefits in favour of corporate interests and private property rights. Far too much power is proposed to be given to the Regulatory Standards Minister. They will appoint all members of the Regulatory Standards Boards, issue guidance on interpretation of the principles, decide which pieces of legislation will be reviewed or investigated, and assess the performance of the regulatory system. They can choose not to review particular pieces of legislation if they politically support them. This fails the sniff test of the key stated objective of this bill, which is to provide and achieve better regulation. The Minister will also be empowered to request information from government departments, council, the Reserve Bank of third-party providers, with a failure to comply being a contempt of court.
Dr. Mills?
Yes.
We're just into the last 30 seconds if you want to make some closing comments.
The Regulatory Standard Board is not accountable to the public. It will be wide open to lobbying by corporate interests, and it will have been appointed by the Minister, so political bias is inevitable. The balancing of interest should remain with elected representatives. Our regulation and laws are there to protect and balance everybody's rights and interests. An extensive deregulation as proposed in this bill would fundamentally change life as we know it and introduce huge risks to the government and our whole country. This bill is unnecessary and is not good regulation, and it should be turned down, removed, binned.
Thank you, Dr. Mills. That brings us to time. Appreciate your submission today.
Thanks very much.
Members, we are now going to break until 1 o'clock. If you could just be back at 1 minute 2, we'll keep on track and on time. Thank you.